Hello, check, check, hello, check.
Yes. It's
Good morning, sir.
good morning.
How are you, sir?
Fine. I'm ready.
So, four students turned up.
Okay.
Sir, with respect to, I wanted to interview you with respect to the court visit.
Yeah.
Sir, cancel कर दिया है. I'll write a mail today. I spoke to Anjali ma'am also. Spoke to registrar sir.
Okay.
Yes, sir. And I spoke to the court authority people. They said that they cannot reimburse the money.
But it can be shifted.
It can be shifted.
Yeah.
So I wrote a mail to them reiterating what they had said to me orally that as instructed by you, the court visit is being cancelled and in near future, if any visitors again
Hmm.
Good morning, everyone. I welcome you all to the one-day national workshop on Critical Analysis on Consumer Protection Act 2019 at Nalsar University of Law, Hyderabad. Before beginning the session, we would like to start it with a 30 seconds of prayer, prayer, since we, would seek the blessings of Almighty before starting the session. All right, thank you. So this workshop is curated in a manner that we have an inaugural session followed by 3 sessions, technical sessions on protection against defect in goods, services, deficiency in services, followed by the second session on redressal mechanism, which will again be followed by consumer protection in digital era, and it will be concluded by a valedictory session. So to begin with, I would like to take this moment to introduce all our guests, esteemed guests and delegates. We have with us Professor Sri Krishna Deva Rao, Vice Chancellor, Nalsar University of Law. We have Professor K. Vidyalata Reddy, Registrar, Nalsar University of Law. We have Professor K.V.S. Sharma, Chair Professor, Ministry of Consumer Affairs, Food and Public Distribution, New Delhi, at Nalsar University. We have Honorable Shri Justice M. Sunil Kishore Jaiswal, sir, retired High Court Justice from the state of Telangana and the state of Andhra Pradesh. We have Professor R. Venkata Rao, Vice Chancellor from India International University of Legal Education and Research, Goa. We have Professor Shashikala Gurpur, Director, Symbiosis Law School, Pune. We have Professor Rajendra Prasad, former Vice Chancellor, Acharya Nagarjuna University, currently Professor of Law at Geetam University. We have Dr. Santosh Kakade, in charge President, retired, State Consumer Dispute Redressal Commission, Maharashtra, currently the Professor of Practice at MNLU, Aurangabad. We have Sri Murali Balasubramaniam, an industry expert in the area of consumer rights and protection. We have Professor V. Keshwar Rao, Adjunct Professor at Nalsar University of Law, former Vice Chancellor at NUSRL Ranchi and DSNLU Visakhapatnam. We have Professor V. Hemalata Reddy, Professor of Law at ICFI. Hemalata Devi, I'm so sorry, ma'am. Pardon me, ma'am, I'm so sorry. Professor V. Hemalata Devi, Professor of Law, ICFI Law University, Law School, Hyderabad. Dr. T. Vijaya Chandra, Professor of Law, retired, Kakitya University. Dr. P. VVS Murthy, an industry expert in the area of consumer rights and protections. Professor G.B. Reddy, Professor of Law from Osmania University. We have Dr. Veena, Associate Professor from ICFI Law School, Hyderabad. He also have Srinivas, Associate Vice President, Bank of America. We have Professor Dr. N. Satyanarayana, an IAS officer, Chairperson TSRERA. So these are the esteemed Hyderabad.
My name is Dr. Vyas. I'm an author.
We also have Professor Aruna Venkat. We also have Professor Aruna Venkat. Yeah. Because I did not see her. I'm so sorry. So all the delegates have introduced themselves. My name is Preeti Anand. I'm also currently working as an assistant professor at Nalsar University of Law, and I'm also one of the delegates. So now that we also have Charan. So I think so. We have had an introduction about all our delegates as well. So to mark the beginning of the session, I've introduced her. I just did.
She also said, follow by
Heard. I did. I just did. My name is Preeti Anand. I'm currently working as an assistant professor at Nalsar University of Law, Hyderabad. And I'm also one of the delegates for the session. Yeah. So I was working with CNLU before. All right, to mark the beginning of the session, I would like to invite Professor Krishna Devarao to deliver the welcome address. Please, sir.
Yeah. Today is a great occasion, and we are all meeting after a long time, meeting several friends and others. I think that's what is consumer protection law is all about. Consumer protection law is the first public interest law in India. 1986 is a real beginning. If you look at in the legal jurisprudence, administrative law, and then looking at who are the public, consumers. And that was the time you have industrialization, globalization yet to begin, that we have seen in 2019 and other amendments. That's, I always say, I started teaching tort law in the National Law School, Bangalore. So go back to Donoghue versus Stevenson, 1935, if I am right. Okay. Suddenly, as a shop, when you open a ginger bottle, there's a decomposed snail. Who is liable? Who is responsible? Is it a company which you cannot see? The outside the cover or the bottle? Is it that opaqueness? How can negligence? That's what is. Tort law basically is about the duty of care. 1986 further exemplified a new jurisprudence. Duty of care, products, and that was the time industrial revolution, factories, manufacturing industry. Still, we have not yet taken over China in the manufacturing. That was the manufacturing. So you all care, duty. That's what care, compassion, love. I'm happy to see all of you today. So many people, thanks to Professor Sharma as a chair professor of consumer law. And so that's what this consumer protection. Let me take a few minutes and then come back, and then I leave it to all the experts, those who are here. So products, liability, fix, compensation, remedies. So duty of care is the basic thing. Duty of care in the deficient products. Then came the new phrase, services. Earlier we were speaking about product, manufacturing, companies. We need company, but we have to fix a liability. And then consumer, poor consumer. We are looking at somebody who's in the village, somebody is in a tribal area, somebody is, he spends all money, wanted to purchase something, mobile or anything, even a food items, food adulteration. Marketing, amazing marketing skills. Yes, we need, but it should not. No, the quality never should be compromised. So that's what I would consider. That's an evolution from the tort law, the product liability principle, reinforcing, reaffirming the liability duty of care. Then came the service. That completely revolutionized. And I remember, in fact, my first article is on consumer protection. Kakatiya University professor Vijay Chandra remembers that was this. And so now look at services. I remember Indian Medical Association 1985 VP Shanta. Huge. Whether a doctor is liable, negligence. That's what the principle, duty to take care. But I know it's a very finest knowledge and skills we need to use, not to just pinpoint that, but some negligence which is a recklessness. All tort law principles codified into law is consumer protection. And then now we have seen, that was in 1986. And then we have seen globalization, manufacturing, industry, export, import. World is at what we call as a Vasudhaiva Kutumbakam. Free trade, everything is coming up. So services, and particularly online ones, e-commerce. No, you look at 2019. And before there were some amendments, 2019 is a major amendments. Looking at e-commerce, huge. Then I would say 2019 also, as a person who has been involved in the access to justice movement in India for more than 3 decades, dispute remediation, full chapter, if I am right, chapter 5 in the 2019 Consumer Protection, mediation is very important. We can't go. And then the purpose of Consumer Protection Act is speedy resolution. It has become yet another court. No, it's not a court. So that's a collective effort for all of us as a lawyers, law teachers, practitioners, consumer. First is education. I always give these two. Consumer Protection Act 1986, Juvenile Justice Act 1986. Why there are similarities? Consumer Protection Act not only speaks about products, services, it also highlights education the consumer important, consumer rights charter. There's a Ralph Nader in the United States, Jaji Madanna, and Manubhai Shah in India, many people. That was this is. So then came even Juvenile Justice Act, yes, what is the best interest of the child? Principles, sir. So similarly, education is important. Education, dispute resolution. I think this is a right time all of us should work with the consumer commissions, forums at the district level, state level. We should take a proactive stance, resolve, mediation. when we were working with the NLS Bangalore in the initial formative years, 90 to 98, I think Professor Venkatrao sir, no, we established in Ramanagaram, just near the Bangalore city, there is a simple legal services clinic and dispute resolution. We used to call both the parties. We are not a court, we are not judges. They used to come and we used to sit with them, mediate, and now you have 2019, Chapter 5 mediation, and also further supported by 2023 Mediation Act. Now it is for us, education, resolution of disputes, and put companies, manufacturers on quality, no compromise, services, no compromise. I think that's what is. I think once again, I thank Professor Sharma for taking this lead, and we look forward more proactive consumer activism which is required. Thank you.
Thank you so much, sir. Thank you for shedding light on consumer activism and how it's become a part and parcel of all our lives. I would now like to invite Professor KVS Sharma to introduce the workshop to all of us.
Honorable Sri Justice M. Sunil Kishore Jaiswal, former Judge, High Court of Judicature of Hyderabad for the state of Telangana and state of Andhra Pradesh, retired President of Telangana State Consumer Dispute Redressal Commission, Hyderabad. Presently, sir is Lordship is Chairman, Advisory Board for the Preventive Detention Act, Telangana State Government. Honorable Vice Chancellor Professor Sri Krishna Deva Rao, Nalsar University of Law. Honorable Professor R. Venkatrao, Vice Chancellor, IIULER, Goa, International Law School, Goa. Honorable Professor Shishkala Gurpur, Director, Symbiosis Law School, Pune. Honorable Registrar, Professor Vijayalata Reddy, Madam, and respected delegates, honorable professors, faculty members, and my dear colleagues. Today I am highly thankful. Murali Saab also is there from Coimbatore, sir. He came all the way to participate in this seminar. And we
for more than 30 years.
And we have former President, State Commission, Consumer Redressal Mechanism, Maharashtra also, and respected delegates. Today I am highly thankful and grateful to all the delegates who spared their valuable time to attend here to discuss on critical analysis on Consumer Protection Act. And when I was holding consumer law chair before leaving, we used to trouble Honorable Justice Jaiswal sir. We conducted more than 20 programs in rural areas. For all programs, we used to request, sir, you have to come as guest. You have to address, you are the appropriate person to to be the chief guest of this.
He
and
also
without
part
saying,
of the establishment of the Nalsar Lawyers.
Nalsar Lawyers.
Celebrating 25
and sir never refused.
from the beginning.
Lordship never refused. He used to come and address the rural areas also by spending one day time Saturday. Every Saturday he used to hijack from Lordship. And the yat bhavati tat nasyati, whatever is created will be destroyed. One eminent professor, he compared this universe with three administrators. Three administrators are administering this universe: Brahma, Vishnu, Maheshwara. Brahma is the creator, so manufacturer is the creator, Vishnu is the marketer, and Shiva is the consumer. Shiva destroys whatever manufacturer creates. So there are three parties in consumer, and every person is a destroyer in this universe. Every person is a consumer. Every manufacturer, every marketer is also a consumer. And this is not a new concept. Even in Vedic period, consumer protection subject was there. If you see Vedas, Vedangas, Upanishads, Ashtadas, Puranas, when all gods and goddesses requested Vyasa to write Ashtadas Puranas, he asked a good stenographer. He should not ask me to repeat. He should not wait, and he should write when I dictate. Good stenographer, Lord Vigreshwara. And immediately everyone requested Vigneshwara to take notes when Vyasa dictated Ashtadas Puranas. And what is the best pen to have to write? Then he removed his Danta. With his Danta, he wrote Ashtadas Puranas. And why I am telling this Ashtadas Puranas, one of the Purana is Garuda Purana. Normally, at the time of death, we used to read. But in that also consumer protection is discussed. And every one of us saw one famous movie, Aparichit. In that, how the hero punished the, what you call, the business people when they, what you call, adulterated the goods or when services are not proper, how he punished. All these are discussed in that. And even in Quran, even in Bible also, all these punishments are prescribed. This is not a new concept, like our arbitration is not a new concept. This is also not a new concept. So many existing laws are there. Law of contract, Sale of Goods Act. Sale of Goods Act says buyer must beware. Consumer Protection Act says seller must beware. So in all these aspects, even today, wherever I go, wherever I speak on consumer protection, I used to tell from last 40 years one thing only. Government is not caring rural consumers. Government is not caring mandal consumers. If you want to strengthen this, first of all, establish consumer redressal forum in villages, then in mandals, then in districts. Automatically consumer protection, when you develop villages, automatically country will prosper. Like that, when you what you call establish redressal forums in villages and mandals. Otherwise, a district like Anantapur, biggest district in India, to travel to headquarters 100 kilometers, the consumer has to travel. And suppose he purchased a 50,000 rupees article, if defect is there, he has to travel 100 kilometers, he has to return, 2 days he has to stay. So at least villages up to 1 lakh or 50,000 give power to some authorities. And similarly, in mandal level also, junior civil judge you can give, then we have district forum, state commission, national commission we have. Then automatically protection of the consumer will be improved in India. This is one. Second thing, in one Supreme Court judgment, Supreme Court Honorable Judge says 75% of the posts are occupied by bureaucrats. Now also if you see NCLT, judicial members are occupied by bureaucrats only, judicial members also. So slowly, in the absence of judicial member also, administrative members, they are hearing CRPC cases, all these cases, and they are giving decisions. Sometimes consumers are facing problems. So at least now in 1993, they prescribed the qualification degree. At the time when they passed the act, no degree qualification, no qualification to become member in state commission, national commission. And a person who is not qualified first standard also, he used to advise district judge, high court judge, Supreme Court judges till 93. And Justice Pasad Committee report, if you see how he criticized Professor Saraf, Jammu Kashmir also, he criticized this. Then slowly they introduced degree is the qualification for becoming a member like that. So like that, if we go on telling, then so many points we have to discuss, because the today's topic is critical analysis on consumer protection. We have to identify what are the suggestions that we can give to the government to improve the act. And we divide the session into 3 parts. First session is dealing with defect in goods and deficiency in services. Second session is dealing with what you call redressal mechanism, district forum, state commission, national commission. Third session is dealing with digital era. That is the main amendment they brought in the new act. Main point they introduced. Even electronic transactions are also covered. So I hope that all participants will give suggestions so that we will forward the same to Minister of Consumer Affairs to introduce in the amendments. So I thank all the participants once again for coming and making success this particular workshop. Thank you. Thank you, and all. Namaskar.
So we have one of the chief guests. One of the guests of honor with us today is Professor R. Venkata Rao. Sir is Honorable Vice Chancellor at India International University of Legal Education and Research. Sir has previously served as the Vice Chancellor of National Law School of India, University, Bangalore. And Sir thereafter assumed the office of Chairperson at Vivekananda School of Law and Legal Studies and Vivekanand School of English Studies on September 2019. So I would like to request Honorable Vice Chancellor, Professor Sri Krishna Deva Rao sir, to present a sapling and a kit that we have specifically designed for this event to Professor Rao.
Yes.
Thank you so much, sir. I'd request Professor Rao, I'd request Professor R. Venkata Rao to address the gathering.
If I'm audible to you, I'd prefer to bypass technology. April 2nd is celebrated as fact-checking day all over the world. And internationally, this day is being observed as fact-checking day to prevent frauds from taking place, to check the facts. And what better day can there be to have a workshop on Consumer Protection Act, the primary objective of which is to make consumer safe and feel secure. I congratulate Dr. K.V. Sharma for having had a holy congregation of 4 generations here. I generation 1995 to 2015 to 3 score plus 10, 70 plus on the other hand, with the 2 younger generations in between. Remember, this is how we pass on the baton from one generation to another generation. I'm reminded of John Keats' words, who said, "You are not the first to be born, you are not the last to die. You have to hand over the baton to the next generation without allowing the baton to fall down." Thank you, Professor K.V. Sharma and Revered Vice Chancellor Krishna Rao for providing us a platform to share our thoughts. My mind goes back to room number 28 of Andhra University College of Law, where I used to meet most of you. Then we used to celebrate the World Consumers Day on 15th March. And I, being a student of literature, I always used to say, before the celebration of World Consumers Day, I was mortally afraid of 15th March, because 15th March was considered as Ides of March when Caesar was assassinated. But with the Consumers Day, Ides of March have been converted into Heights of March, of providing access to justice. In any country, people are poor not because they have no money, but because they have no access to institutions. And 2 of the greatest things to have happened in the democratic saga of India are the Right to Information Act of 2005 and Consumers Protection Act of 1986, where metaphorically and literally the doors were open to everyone. And in partial fulfillment of WTO obligations might have had Consumer Protection Act, but the consumer was unheard, unwept, unswung up to 1986. And from 1986 down up to 2015, when much water had flown, the Parliamentary Standing Committee came and said, even if Rousseau were to come today, who said man is born free but he is everywhere in chains, would be constrained to change it. Man is born free but he is everywhere in digital chains today. And because of the humans becoming digital humans, because of the consumers becoming digital consumers, because of the citizens becoming digital citizens, because of the cynics becoming digital cynics, there was a need to re-adopt ourselves. Therefore, the very successful Consumer Protection Act 1986, I say it is a thumping success, but yet it needs to be improved upon. Otherwise, the fate that would have happened to Kodak films would have happened to Consumer Protection Act also. Therefore, there was a revision in 2010. And because time is short, I'll be focusing just on the remedial measures that are required to be taken as far as 2019 Act is concerned, without going into the chapter of definition, jurisdiction, producer's liability, etc., etc. The first thing my mind goes to is the seminal work of Professor V. Keshavarao on advertising for his PhD work. When nobody thought of advertising in the corporate sector, he came out with that. And today, when I look at the Consumer Protection Act 1986 and 2019, my mind goes to a concept called surrogate advertising. Now, when I look at the concept of surrogate advertising, I'm constrained to recall the words of Michael Friedman, who, while observing the consumers' movement, said, many people want consumers to be protected by the government. A much more important problem is to protect the consumer from the government. Well, it's true, consumer needs to be protected by the government, but it's also equally true, a consumer needs to be protected from the government. If you look at surrogate advertisement, which definitely Professor Keshavarao would like to amplify, you would be knowing as to how you are being taken for a ride. That is one. The second one is a really path-breaking provision in the new act is mediation. One part. Totally solved, partially solved also. Mediation is given credence to. I cannot but recall the words of Mahatma Gandhi, who said, 85% of my cases used to be settled through mediation in my outer office. And Mahatma Gandhi makes a very pertinent observation. I recall, he says, whenever I used to solve a problem through mediation, my joy was boundless. I had learned the true practice of law in mediation. I realized that the true function of a lawyer is to unite the parties who are driven asunder because of misconceptions. And during the 20 years of my practice as a lawyer, I lost nothing by solving cases through mediation. Certainly not my soul, he said. I have not lost my soul, and that is what the advocate should look for. But the skills that are required for mediation are totally different that are required for advocacy. I'd be very happy if Professor K.V. Sharma, Krishna and their wonderful team also initiate the measures to churn out mediators to settle disputes under Consumer Protection Act. That would be the real continuation of this workshop. Please churn out mediators who can help Consumer Protection Act 2019 deliver the goals. Then there are 4 areas which need to be understood. Number 1 is the right to repair. Consumer Protection Act 2019 wanted to dabble with it, but today every one of us is being hoodwinked by the multinationals like Apple, who every 2 years keep on changing the brands. And when we ask for repair, they say we cannot repair, so you must go for new one. And they place you in such a tight corner that you cannot go out of it. And right to repair is not recognized. And time has come for us to follow the measures of the Ministry of Consumer Affairs, which has set up a committee to come up with the right to repair framework. It is going to be of considerable importance. 2019 legislation needs to be improved upon by focusing on right to repair. Then there is a session on RERA. In the valedictory, the specialist from RERA is coming. And today, the most vulnerable consumer is the prospective buyer of land, notwithstanding the Supreme Court's judgment in Imperial Structures Limited versus Surinder Anil Patni. Much needs to be done as far as the relief to a consumer under real estate are concerned. The third one is deficiency in online medical counseling. See, I come from a family of doctors, Professor Kesara is having a willful smile. The less we talk about online medical counseling, the would be. Therefore, we need to discuss about that online medical counseling and how do you improve upon it. The next one is regulating the direct selling market, the so-called fast-moving consumer goods, the so-called fast-moving goods companies, remember, need to be taken cognizance of. I thought that these were the 4 bullet points that are required to be put on apart from mediation. The last one is the debate as to whether advocates should be brought within the Services of Consumer Protection Act a debate. Now, are advocates holier than thou? When you are bringing doctors, chartered accountants, and you cannot, can you cite simply professional misconduct and the provisions relating to Advocates Act saying that we should not be brought within? No. Deficiency of service wherever it is. And 2019 Consumer Protection Act, remember, needs to, I don't say spread its tentacles, needs to extend even to the professional misconduct of advocates. I'll be very happy if the workshop deliberates on these 5 issues. Thank you very much, ladies and gentlemen, for giving me patient hearing. Thank you very much.
Joint Nalsar. Specialization is brief secretary Nalsar is watched it. Each by specialization. First they will.
Thank you so much, sir. Thank you so much, ma'am. Thank you, Professor Rao, for highlighting the goods and bads of the Consumer Protection Act of 2019, what's there to be worked upon, what's there that has been addressed, and what are the changes from 1986 Act to 2019 Act. Now, I would like to call upon Professor Shashikala Gurpur, Director, Symbiosis Law School. Before that, I would like to request Professor KVS Sharma to Professor Shri Krishna Deva Rao, sir, to felicitate ma'am with a sapling and a resource kit. Thank you so much, sir. So I don't think Professor Gurpur needs an introduction, but then just to bring all of us on the same page, Professor Gurpur is a distinguished academician and an orator who has presented more than 325 invited lectures, workshops, seminars across India, Thailand, US, UK, Ireland, Germany, Australia, Canada, and UAE. She has had an outstanding academic landscape with a wide range of experience in teaching, research, industry, and is currently working with Symbiosis Law School as the director at Pune. I would like to request ma'am to.
Also former member of the Law Commission of India.
Ma'am's also the former member of the Law Commission of India. So I am so sorry to have missed out on important information. I request ma'am to please address the gathering.
Yeah, I can. It's okay. You can do that. You can do that. Respected Vice Chancellor Sir, Honorable Dais, Professor Sharma Sir, whose blessing has brought me all the way here, and his great personality along with Dr. Rao Sir, and all my friends and colleagues. I have my PhD student and erstwhile colleague Dr. Kakade here. I have many others, my own colleague Kunche Shanti here from Symbiosis Law School, Hyderabad, among others. So today, I think it's a great dais where I'm given the opportunity to be the guest of honor. I deem it very great privilege for many reasons. First of all, today is the day I finished 17 years with Symbiosis. I never thought that I will stay in Pune, which is not my hometown, or I had very deep entanglement with literature, etc., and grassroots movement in Karnataka with the connections from Chennai, Hyderabad, etc. So it's such a surprise that on this day I'm in Nalsar. And secondly, I also had the distinction of teaching law of torts in Bangalore National Law School as one of the pioneer faculty way back in 1995 before I decided to leave National Law School. And aside from Sir National Law Commission's membership, I was the General Counsel member of Nalsar for 3 years between 2011 and 14, although I had the privilege of visiting only twice because of many other reasons. So I'm very happy Dr. Rao is here now and Dr. Sharma are here. So it becomes again a home to visit as much as possible whenever I visit our sister institute in Hyderabad. Today's half of my work has been made easy by Professor Rao's distilled observation on law with the kind of seniority and scholarship that he enjoys, and also the kind of observations as he has made. Each of the observation is, I think, 1 year research agenda for all the people involved here, the advocacy group, and we have the consumer advocacy group, we have the Center for Corporate and Competition Law, and the chair which is there. But I am going to highlight, because you have titled it as critical evaluation, critical analysis. And for me, the word critical means evaluative, where we are looking at the strengths and weaknesses, especially from the point of view of the new avatar of this law. 1986 law was recast as 2019, as Professor Rao said, Consumer Protection Act. Vice Chancellor Rao said that. And he also highlighted the strong points of this law. But my question comes from the latest research which came from JNU, an unpublished research guided by Professor Chimney and Professor Hegde by a student called Soumya. I had the privilege of being her referee, and I thought I must highlight one point in that research where she talks about, and the scholars guide her to look at the international underpinnings of consumer law in terms of sustainable development goals and in terms of how consumer law as it is now, whether it is through the United Nations mediated fora and thereafter influencing the national legislation, looks at consumers as homogeneous body. Consumers are not homogeneous body. A consumer in Africa, a consumer in global south is very different from the consumer in the global north. Consumer in the global north is very much dependent on market because they don't grow much there. Everything is taken from global south. 4/5 of the consumption of the goods from the south is happening in global north. So in that context, consumer rights as market centric, business opposite rights is good. But when it comes to global south like us, we are dependent on nature. So for us, there is no concept of consumer right unless we are looking at sustainability. So the sustainability, because I also hold the Jean Monnet chair, which is funded by the European Union on climate justice, and my whole research has been around the climate justice. I came upon this concept of ESG, environmental, social, and governance dimension in corporate law, which is Professor Sharma's core area. And that is where this could link, because in Symbiosis Law School, before I took over, students had organized an extracurricular, co-curricular forum called EcoCon, which is about linking ecology and consumer protection. So there is no consumer protection in Global South unless we look at it from the point of view of sustainability. And that's the point I want to highlight among many other things which I prepared for. Most of them, sir, as both Dr. Rao, Vice Chancellor Rao and Dr. Rao had touched upon. But if we are looking at one of the rights in consumer protection, right to safety, that is the most important right as far as India is concerned, because India still has large majority of illiterate people who will go and compromise their safety with non-ISI sealed gas cylinder, ranging from that, who are so much not in consonance culturally with the law, would like to stop their beeping safety belt. They will go and buy such alarms from online digital means. So the right to safety, if you look at it, and if you look at it from the point of view or compare it with the right of choice of the consumer, which is there in the Act, and then right to access to basic necessities, which Indian consumer or consumer in the poorer parts of the world suffers from. If you see the coordinate interrelationship of these three rights, Consumer Protection Act on its own does not talk about it. We have to see it in the dynamic, organic context of how the community of consumers is responding to this right. I remember in the feminist forum in the university where I studied in Mysore, we were talking about how women had only one cotton sari, which they used to manage in the whole year because they could not think of feeding their child or looking at other issues. So my colleague feminists used to say the greatest advantage that has been done by the market is nylon saris and polyester saris, which these women can afford. But do you know the disadvantage? The minute they go near the open fire, the danger is manifold. Now, it is like bargaining your survival. So nylon saris advantage in terms of basic necessity of cloth. Water, for example, food, shelter. I mean, food, used food, they use. Second-hand food, consumed food which is frozen and then sold. So these kinds of things. And medicines, as sir pointed out, the cheaper medicines which are actually counterfeit or which may be second-hand, I mean, second-grade medicines. So right to access or right to have the consumer pleasure of consuming goods and the vulnerability of illiterate, not very aware, not being able to afford these consumer goods, have we looked at it? So there is a need for the social audit of this legislation, which hasn't been done. Unfortunately, it was just 1 year before the COVID. And during COVID, we saw the vagrancies of consumer rights being going here and there. And I don't know if political exigency is a justification for deprivation of justice. So that is one. Second is all the United Nations and parliament-driven legislations, assembly-driven legislations, how are they socially audited? If we were to do a social audit as a law school or from the advocacy point of view, how do they look like? So these are the questions I will throw open, and looking at consumers not as homogeneous unit. For example, asbestos. Do you know about the asbestos case? The asbestos which is mixed with the baby powder manufactured by Johnson, and it was rejected by the European countries. In India, same Johnson baby powder is available in the market. So many drugs have been called off. For example, children misbehaving after consuming cough syrup. Sir, you talked about the medicines. I was surprised to see in some medical stores still that ingredient in the cough syrup is present, and such cough syrup is being sold in Indian medical shops. And this is all happening because that's the cheapest medicine. Affordable alternative is not there. Alternative knowledge is also not there. Therefore, our primary right as educational, sir said about education and intervention, begins from both these angles. One is advocacy and the other is education, the campaign. And the education, it's not just about the legislation. Give them the role play, give them the case studies, give them the case laws in a very simple way. So one of the allegations against this current Consumer Act is it is so huge with so many annexures and so much of complexity. Does the law need to be so complex? If it is so complex and if it is meant to touch all our 1.35 billion people, then how can it reach? What about the language translations? What about the simplification? So the purpose of the amendment was to help India to have edge in terms of Make in India campaign and right to repair as part of that. And then also, I remember in my childhood, I had only one pen for the entire primary school period. One is you refill with the ink and all the time ink in the hand because the pen doesn't remain constant. I mean, it gets leakage, etc. And no question of throwing the pen with the refill. You would use the refill. And this refill was always plastic, which we didn't think at that time. Today, refills only become the biggest garbage here. And as sir said, I always said that if Steve Jobs were to be alive, how much more money you would have robbed from the society? I'm sorry to say this, with the new designs, because every time a new design came, the old had to be dumped. And so much of e-waste is generated. So I'm looking at it from the point of view of climate justice. I would call the House to put this point of climate justice and sustainability as one of the aspects of consumer in the South, who has very close relationship with nature, where the resources of the nature and the consumption patterns need to be seen. Now, it came in the wake of economic liberalization, globalization of market, and digitization of products and services. Now, this is exactly where our problem comes. We have seen between 2018 and 2000, as of now, 1,400% increase in the complaints as far as digital consumption is concerned. That means there is sometimes no delivery. I don't know how many of you have experienced as consumers. You pay and the delivery is not there. He goes and delivers in some other apartment complex in the urban area, or shipment of the incorrect or faulty product, late shipping, lack of refund, replacement concerns. For example, he replaces what you don't want. I wanted a wrought iron pan and I was given something which was completely rusted, and then I had to reject. He said he will replace, and he replaces with the worst one. So then you give up, Should we give up? If we don't want to give up, do we have a forum to go? As sir said, hundreds of miles here to walk. So this is one. Second is, in Digital India, the Make in India initiative is there. How much of this consumption is Make in India oriented is another question. Is our wealth coming back to us? Are our SMEs, small and micro enterprises, gaining from this Consumer Protection Act when it is so complicated? And then we also saw that government was going to promote the e-commerce platform, but is the government addressing the issue of the e-consumer? No. So courts had to intervene in the Flipkart case in 2022, where they rewrote the contract because the platform which was selling these goods was considered to be a mute spectator, whereas it was making huge profits. During COVID-19, only Amazon and such e-companies raised their profit. So did we look at this kind of a concentration of wealth and the corresponding poverty of the consumer? So this is what the law needs to balance. The critical evaluation has to look at that kind of balance of justice in terms of multifarious, overlapping, and competing rights. And sir said about misleading advertisements. My concern is on what we call as greenwash advertisements. The greenwash advertisements are like this. They will tell you that this is a better alternative to protect the environment. But then, for example, now we are being talked about better alternative to certain things. What example I can take? Like this nylon only, better alternative and affordable alternative. But then in the long run, it is such a dangerous alternative. So the accurate communication in terms of environmental benefit, nutritional benefit, safety concerns need to be there. Therefore, next slide. So bank report and other things, I don't have the detail. So what we have to do is enlightening our customers, consumers, wherever you are doing the consumer literacy as a forum in your law schools or in the Nalsar leadership, how we can encourage our consumers to be green compliant, environmentally compliant. Like in one of the schools, we went and did a session on enlightening the little kids about Environment Day. So I asked them, how many times do they buy bags in a year? I mean, we were given bags only in the beginning of the academic year, however rich the parent was. Secondly, how many times do you buy the pen? What do you do with the used pen? They said, we throw. Where do you throw? We just throw. So nobody thinks of where that waste is going, how that is going to be dumped. And then the manufacturer is very happy. He is having a gala time manufacturing these goods. Therefore, consumption patterns in terms of their green impact and sustainable impact, in terms of their safety, in terms of the vulnerable South, global South lifestyle is what I would like to highlight. So criticism of this legislation, one is complexity and the length of that. This is the size of the new legislation, thankfully, sir brought. And the old legislation was barely few pages. Second is impact on innovation and competition, because there's so much of Western dominated approach here and global big players dominating here. Third is burdensome regulations for businesses. Even the businesses are not very happy because they are not enlightened on how to be sustainable. Delays in redressal, which all of us know, general problem of Indian judiciary. This is no exception. Lack of clarity in definitions and provisions, and very limited coverage of e-commerce, because now e-commerce is throwing other challenges. Your data privacy, you give the data on this platform, everybody else has your information, whether you want it or not. They say that once you enter this social media, you have a police officer running or detective running after you, a psychopath running after you, and a psychiatrist trying to collect data or psychology analysis, and then all other strangers. So you become a pie for everyone to eat with. So this is something that needs to be protected, the data privacy issues. And with artificial intelligence, many other dangers are there, even fraud, that somebody will come to supply, and other vulnerabilities. Somebody comes to deliver the goods and barges into the house and attacks women. We have had complaints of this from our students. So where exactly are we going to nail this e-commerce as consumers is the new challenge. I mean, if you are with the community, you will agree with me, or as a member of the community. Now, how to protect a consumer who is ignorant about the ISI valid mark or compulsory business standards? That protection is not there. It is like ignorance of law is no excuse, but is ignorance of rights as consumer or awareness of that product being taken in the same way. For example, microwave ovens. Everyone wants to have that fashionability without knowing the radiational and other side effects. So didn't we live in olden days without any of this? Sewing machines, for example, water heaters. So new consumer preferences and tastes being created by the market, and that resulting in new problems. That needs to be tackled in a holistic way, and the legislation from that point of view needs to be understood with its limitation, and the interventions by institutions and educational campaigns need to have a holistic approach. And another thing is the corruption and lackadaisical nature of the enforcement agencies, which in a way have not impeded consumer exploitation or unfair trade practice. And with the technology, with the blockchain especially, where whole mass is available and standardized contracts are there, it is very difficult to fix the onus. So law needs to be making the onus also equally liable. You make big money, you pay big money as compensation. So in Indian courts, these gaps are trying to be filled, as we saw in the Flipkart case. But Indian court, as the mouthpiece of the welfarist state, being the independent organ, can do that. But how long can it do? It cannot go faster than the technology. So the technology needs to be seen also from the consumer preference point of view. Let's go to the last slide. This is the last slide, way forward. So here, as the guest of honor, I feel that today's workshop has taken all the 360-degree dimensions, especially the deficiency in goods, deficiency in service, digital consumer, and other approaches. But I feel that going forward, because this is the only opportunity I'm getting to talk, so I thought that I will throw these seeds of ideas with you. You can research on this. You can develop an advocacy campaign. You can develop a project for funding. You can do a collaborative activity with the CSR fund of the corporation. So one is effective implementation aspect to be looked at, where unalterable kind of contract need to be reviewed, getting that critical sense in the students, which the court said in the Flipkart contract, but that it is not that sacrosanct. If the contract is uneven, then it needs to be revisited. So unfair trade contract and compensation awareness. Second is capacity building in terms of consumers and businesses on negative effect of competition and differential pricing. different platforms, differential pricing. Flipkart gives one price, Amazon gives one price, and then Amazon eats up Flipkart. So all, the business world reality needs to be known to the consumer. Awareness campaigns on fraud and fraudster websites. So campaign has to go with the cyber cell and cyber technology in terms of misleading advertisement and training on that, because fraud is a huge issue now. You could become vulnerable. You are not just consumer, you become vulnerable to crime also. So their awareness has to come. Engagement with the stakeholder through education and other avenues in terms of consumer empowerment, like sir said, mediation training, for example. Integrating, this is my focus today, integrating principles of sustainability and sustainable development goals by accepting that consumer is vulnerable as well. Large percentage of rural consumers are vulnerable because of the affordability and awareness issues. So their category of consumers to be separately tackled by our different law schools, and monitoring and evaluation of the legislation as we are doing today. I once again thank Chancellor Rao sir and the wise leadership of Dr. Sharma sir. It was for him that I came, otherwise today I would headquarters. Thank you, sir, for accommodating, and all the best to this workshop. And I congratulate each and every one of you who is here to participate, contribute, and also to act as a resource person. All the best.
Thank you so much, ma'am. And congratulations, since you shared that you have just completed, today is the day that you have completed 17 years of services at Symbiosis. Thank you for giving us this insightful approach to looking at consumerism and how sustainability is also important. I mean, I'll just take 10 seconds to express how currently there are so many social online shopping platforms that would sort of give us an opportunity to waive off some of the rights. For example, the right of choice. I mean, they would offer some products as a lesser price. If at all, you promise that you are not going to return it. So no return price is comparatively cheaper than, let's say the product is for 300, and if you buy it for, you can get it for 280 if you promise a no return. So that also puts me in I think it's a matter of concern that we are sort of paying something or, for waiving off our right of making the right choice as consumers. We moving on forward. We now have the chief guest of the event, Honorable Shri Justice M. Sunil Kishore Jaiswal, and I would like to request our Honorable Vice Chancellor Sir, Professor Shri Krishna Deva Rao Sir, and Professor K.V. Sharma Sir to present the sapling to Sir, along with the resource kit. So I again do not feel the necessity to introduce Honorable Justice Jaiswal, and also I feel that Professor Sharma had already introduced, but to again bring us all on the same page, Professor Honorable Justice is a retired judge from High Court of Judicature at Hyderabad for the state of Telangana and state of Andhra Pradesh. He is a retired president of the Telangana State Consumer Dispute Redressal Commission, Hyderabad, and is currently the chairman for the advisory board for the Preventive Detention Act at Telangana State Government. And having had conversation with Sir for 1 hour while we were traveling towards the campus, I believe Sir has a lot of experience to share, and I would invite Sir to come up to the podium to share his experiences with all of us and address the crowd.
You take your
The problem is our practical things, will it take a lot of time.
Take your own time, no time. You will extend.
Thank you, sir. A very good, warm good morning to all of you. At the outset, I feel privileged to be part of this inaugural session of this critical analysis on CP Act 2019, it is embarrassing for me to address the eminent and top-ranking academicians. I'm sorry if I say that I feel I'm odd man here, because academicians and the people on the practical field have got different approach and different notions about anything. You people make laudable legislations, laudable suggestions, but when it comes to the ground reality for practice, we see altogether a different situation there. Not only as a High Court judge, district judge, magistrate, sub-judge and all that, for the last 45 years I had been in judiciary as a judge, but even for this 5 years tenure in State Commission, what I find is, though things are said, very laudable things are said, very goals are set, but when it comes to ground reality, the situation is completely negative. You may kindly pardon me if I talk only about, because we are supposed to make a critical analysis, not the benefits of the legislation. What is the things that are lacking in this new legislation is very important for us. So when you have the sessions afterwards, you can in-depth make analysis and come out with some suggestions. Why this even 2019 Act may or may not reach the objects. The legislatures, lawmakers in their wisdom, they make very beautiful legislations. But when it comes to the implementation part, we find, as a judges, we found that a lot of things have to be done which have been assured in the legislation but not implemented. Let us, for example, I'll just deviate from here. I will take up our own legislation of 2019. What does the Act say? The very object of this enactment is expeditious disposal. And the Act says provide so many things, so much infrastructure, and also enhance the strength of the commissions, district commissions, state commissions. But with due respect to the authorities that be, nothing of that sort is being done. As a state commission chairman, Mr. Sharma knows me, 5,000 cases were there and only I was heading that. I was the only officer working there. I'm supposed to have 5 more officers. None of them were appointed. For 2 years, single hand. What can I do? 5,000 cases, can one man handle? I can't do more than 5 or 10 cases per day. Even if I'm efficient to the highest level, I can't dispose of more than 5 or 10 cases. Hundreds of cases are there on the list. Consumers will come. Virtually, brothers and sisters, I have seen them crying in the court. Yes, they are fully justified. Because petty things, small things, big billets are the luxury of waiting for the litigation to go on. But what about the poor people for whom the legislation is intended? No infrastructure. Even an internet network was not working in my court. No computer, no laptop, no nothing. When we asked the government, I should not comment, but because come from the ground level, I'm telling you, when we asked for the government, they said next minute we'll see. Not even a single computer was provided to us. Thank God that NIC has come forward, National Informatics Center. They gave computers and then somehow we are able to manage. No staff. No stenographer, can you believe? For a judge, a stenographer is a must. Long back when Khamam, I told him on press conference, I can skip my breakfast, but I can't skip the presence of my stenographer in the morning at 8 o'clock. Because the life is such. Our life starts at 8 a.m. in the morning with the stenographer's arrival, where we will dictate the judgments and then proceed to the court at 10:30. If that stenographer does not come at that time, entire day's work is collapsed. The judgment which was pronounced tomorrow will have to be postponed by another day. So no stenographers. If you go to State Commission, you will see. Sharma is a witness to that. I think Balakrishna is also a witness to that. No computer operator, no stenographer, no nothing. 6-7 staff is given. Act says, see the Act, they provide so many things. So what I'm trying to say is, provisions making in the Act is good. But when it comes to implementation, now if I address a gathering, they question me, sir, you say that 6 months is the time limit for the case. My case pending was now 6 years. What answer should I give? I have to cut sorry figure before them. Therefore, I was telling Sharma, please avoid calling me to the functions because I can't answer their questions. So the money ఉంటారండి లేచి అడిగేస్తారు అయ్యా మా కేసు 6 years నుంచి మీద పెండింగ్ ఉంది మీరు ఏం చేస్తున్నారు అనేసి. What answer can I give? I used to openly say, I'm sorry, I'm unable to raise up to the expectations of the society so far as this consumer movement is concerned. Because the peripheral area was not with us. Entire thing depends upon the Secretary of the Consumer Affairs For him, it is only small limb. He is heading civil supplies and is ex officio chairman, ex officio commissioner of the consumer affairs. Last preference, consumer affairs state commission. Walls are falling. Officer was sitting, a big wall fell on the road. This is next year we will see. So anyway, this practical diffusion. Therefore, academicians and practical side, there's a lot of big gulf is there. That has to be filled. Occasions such as these workshops should endeavor to come out with concrete suggestions, and that should be rooted to the authorities that be, and that something should be done. Something should really be done. No doubt, the Act says it is you must have 5 members in the state commission. But who is to appoint? State government. What to do? Only 55,000 rupees per month was being paid to a member. Can you expect a good person to come and work as a member of the state commission for 55,000? An advocate with 5 briefs, he will not prefer to come to state commission. 55,000, nothing else. When I was there, when others they made 75,000. It's a pittance. So naturally, the unwanted stuff in the profession, they will prefer coming here because this 50,000 is better than loitering on the roads and corridors of the courts. What has to be done? How to get the best people available in the market to the field so that they can do effective justice. Selection procedure. Since Sharma gave the liberty of no time, I am going on telling. Selection procedure in the old Act, the president of the state commission was the chairman, law secretary and the department secretary were the other selection committee members. So entire thing was in my hands to appoint, select people, not appoint, to select people and recommend to the government as and when need arises. With due respect to the new Act, they have completely bypassed that legislation. Now state commission president has no role at all in the selection. He is the main stakeholder there. The people you are appointing have to work under him, and he has no say in the selection committee. They have removed the president of state commission. They have removed the law secretary. They said, Honorable Chief Justice or his nominee. Yes, Honorable Chief Justice and nominee are more learned, more brilliant than we people. Yes, but we are the people who are dealing with this specialized subject. We know what is required for a consumer court judge. What is the need of a president of district commission? How a member of the state commission should be. We know more than what my learned brother in the High Court knows. They are very intelligent. I am not saying that. They are not on the ground. For your information, I came to know about the Consumer Act only in 2018 after retirement from the High Court. Though I was there for 42 years, I never came across CP Act. I came to know only when 2018 when I joined here. So many of us do not know all the legislations. We only deal with some certain branches of law in the High Court or District Court or Sub Court. So we are supposed to have a specialization. The State Commission President is now removed. Hopefully on 5th January is there the Supreme Court. This month, day after tomorrow, let us hope that Supreme Court will do something good for it. In fact, if you have read in the newspapers, CJI was very furious. New Act says any person who is a High Court judge or is eligible to be a High Court judge can be appointed as the President of State Commission by appearing for the written examination. So High Court judge 10 years standing, that's all. Any advocate with 10 years standing, irrespective of his practice, can appear for the exam. And if his fortunes are good, he will be selected as the President of State Commission. And all the district judges, retired district judges who are working as district commission presidents have to work under him. Previously, that was not the case. This is only a retired High Court judge. So certain changes which are brought about, in spite of our strong resistance, the authorities have not heeded to our advice and they did their amendments. So there is one area where you can ponder over it. Of course, Supreme Court is seized. On 5th and 12th, we are having very important cases. It has been challenged before the Supreme Court because selection committee. Now the CJI the other day in the open court, he said, I think the President of the State Commission should be in the selection committee. So the Honorable Chief Justice orally said the selection committee should consist of a High Court judge, State Commission President, Law Secretary, and the Department Secretary. Now that is not the case. A High Court judge, Secretary of the Department, and nominee of Chief Secretary. You see of course, I can critically comment, you can see the way it is set up. 2 from bureaucracy, only 1 from High Court. So the people who want to have their say, they will have their say because 2 of them are their members there. And it did happen here. If you permit me, I can give instance where the political influence did happen here.
They appointed a person who was 10 grades below, only because one master sitting in the corridors wanted that person to be appointed. Because two of them were there, veto. Even Hakoji cannot do anything. So such practical difficulties are there, my extreme gentlemen. I have a high regard for you people. In fact, you are all our teachers and gurus. We learn so many things from you. But I have seen the world from other side, which of course seldom you happen to see. It is just like, to tell something to people like you, carrying coal to new candles. You people are all thorough in that, and all things are there. Before I got to that, some things which said mediation, sir. Yes, mediation is one of the best piece of new enactment. But with due respect, VC Garu, in this particular branch of legislation, I find that, it's my opinion, that mediation may not succeed as much as it does in other branches. The reason is simple. Here, small people are pitted against big people. I happen to deal with cases, if I start telling the cases, you will be surprised. A biscuit, Parle-G biscuit, small piece of particle, foreign particle came to the biscuit. That poor lady has filed a complaint. And for that biscuit of 5 rupees, she has already spent 10,000 rupees here. And the man who is pitted is multi-level company. Can that poor lady withstand the onslaught of senior advocate engaged by a multinational company? They have to give up. And if we refer such matters to mediation, there also they will have their upper hands. So, because the fight is not between equals. The fight before Consumer Forum is not before equals. One is purely a victim. Yes, victim. No doubt about that. Other is a high. Many cases, if I start telling cases, even 10 days is not sufficient for me. Small cases. Oh, sorry, when the girl was coming, woman was coming from LB Stadium after a function. She was having a pattu sari. The pattu sari got stuck in some iron protruding in the bus, and the sari got torn. For the 2,000 rupees sari, she spent 20,000 rupees. But still, she was yet to get justice. Because that belongs to Kalanikethan or some Chennai company. RTC is on the other hand. So these unequal fights are there. Therefore, I don't mince words in saying that we find we are failures in implementing the laudable object of the enactment. Yes, Act says so many things. But why, how to do it? How to handle that? We need additional, at least State Commission needs 3 benches if we are to tackle the pendency of 5,000 cases. Otherwise, the consumer who comes there has to wait for 5 to 6 years minimum. Another amendment is pecuniary jurisdiction. If you have read the Act, you will find that the pecuniary jurisdiction has changed. 50,000, 50 lakhs. It was 1 crore in the Act, subsequently amended to 50 lakhs. Up to 50 lakhs, District Commission. 50 lakhs to 10 crores, I think, State, 2 crores, I think. State Commission, and about 2 crores, I forgot because one of years. See, the problem here is, on the face of it, it looks very attractive. But if you go in depth, and if you practice that, you find that it is a mirage. Because they have changed the very concept of the consideration. Previously, in the old Act, it was the total value of goods and services put together should be taken as consideration for determining the jurisdiction of the different hierarchies of the Act. That means, if a flat is there, if the defect in the window, they take the value of the flat and everything and then determine jurisdiction. Total value. Now they said consideration paid. That is a very dangerous thing. Because I never came across any case where the consideration paid for any property was more than 50 lakhs. Even the highest apartment, luxurious apartment also, I don't think they will pay 50 lakhs initially. Even if the flat is costing 2 crores, they won't pay 50 lakhs. So what happens? Okay, the intention is, yes, I appreciate that. They wanted that the adjudicating authority should be to the nearest place for the consumer. Yes, that is the object. But in the process, what's happening? All the cases, high-end cases, high-stake cases are going before the district forums, district commissions now called. Because 50 lakhs consideration. For example, I was telling my sister in the car, liver transplant case was there before me. The total fees paid by for the liver transplant was 25 lakhs. So if the case has to be filed, because the consideration paid is 25 lakhs, it should go before the district commission. So the consideration paid has completely changed the setup of the thing. Previously, value of the goods and consideration. Suppose I have to claim for window, what is the value of the flat? Say 1 crore. So 1 crore means come to state commission. What is the value of the flat? 25 lakhs, go to the district commission. So value of the goods and services thesis, now they made consideration paid. So now what's happening is the practical difficulty is the consumer forum is completely, district forum is completely devoid of any infrastructure. If you go to Nampalli, I'm sorry, you can't even sit there where we are having our consumer commissions. What happens now? So right from the person who has got a grievance for 100 rupees to 50 lakhs has to go to the district commission. Multiple litigation there. Everything is before district forums only. So that man who's claiming damage for refrigerator costing 5,000, AC costing 12,000, motorcycle costing some 30-40,000, address car costing some 10 lakhs, has to go and stand in the queue with a person who is fighting for the 50 lakhs litigation case. So this is creating problems. The moment there's a consideration paid, I'm really telling you, I'm yet to come across only 1 or 2 cases where they paid more than 50 lakhs. Because the litigation starts, the problem with us was these builders. The main litigants before consumer forums are builders, then medical negligence, then insurance companies. Insurance company, you might have seen, for fire accident, what is the premium paid? Has to be taken into consideration. Previously, we used to say, what is the policy of sum assured? Thereby, we used to determine jurisdiction. Now, premium paid ante, hardly you will come in a case where the premium is paid more than 50 lakhs. So that is causing some problems for us. Practical difficulties are there about, and there was some mediation. I find it, of course, it is a very good thing, provided, but the thing is, here, the people who come are very poor people, as you have already said, very poor people. They can't afford the luxury of, again, asking them to go before a mediator. They say, sir, we came to you, you assured us justice within 6 months, mediator there, why are you sending us to the mediators? And about the mediator's performance, it is not that high-end mediators are, your high-end mediators are different. Here, we will appoint somebody from the district commission advocates who have no practice at all. Second thing is, what about the remuneration to mediators? When I was the state commission, when I was appointing mediators, first thing they were asking is, what is that you are going to pay? Nothing. Who will come for, very rarely we come across people, who are prepared to work for gratis. In this W, how much money you are going to pay per case? We can't pay anything. Asking the consumer to pay is nothing but taxing him double. He paid some court fees here. Again, ask him to go and pay for mediators. Again, execution. The order of the mediator is not final. Again, they have to come before us. So these things, because the nature of it, yes, mediation is very successful where, high-end companies are there, arbitrations, where they can't, they can wait, but they can't have the luxury of long litigation. They want to solve then and there. We tried. Even we tried in medical negligence cases. I can confess before this gathering that I used to call the chairman of the hospitals and tell them. In one case, in fact, I gave a warning to the hospital. If you won't settle the dispute with that poor person, tomorrow I will give a judgment and write strong strictures against your hospital and see to it that nobody comes to your hospital. Well, you want that? In another case, Apple phone, iPhone, I think. 80,000 phone on top in those days. There, one man got 3 iPhones for the 3 brothers. They were not working. They went to the Secunderabad office. There they were harassing. Same thing. I called the advocate and said, brother, if your people are not going to solve this dispute, tomorrow you will come out with judgment, with severe strictures on you, and your entire company will be put to risk. Then they settle the matter. So sometimes, we call it carrot and stick policy. Sometimes carrot will work, sometimes stick will work. Always it is not possible. In doctor's case, I used to tell them, doctors, please, we know, see, the medical negligence, of course, my senior doctors are here, is very delicate issue. Either thing can be said on either side. There is the possibility of negligence, there is possibility of wrong judgment, there is possibility of something happening. I did one case, where for a small operation of sinus, sinus. For sinus, Dr. Hare Krishna was ENT specialist. He did something here and that complaint was a constable, traffic constable from Warangal. He lost his vision. The entire eyeball was not rotating. Eyeball మొత్తం బండనే అయిపోయింది. పత్రిక సోగా ఆగిపోయాయి. And the vision is not there. Because the traffic constable, he was asked to go on leave. Then I called Dr. Hari Krishna, what happened? He said, sir, sinuses means bone, bone will be there here, we have to rub it. So in that rubbing process, if some slight more pressure is applied, it immediately affects the eye. Because the closest part is eye. So probably that happened. Now what to do? But see the result? The negligence of a fraction of a second has resulted in very grave consequences for that man. He lost the vision completely. I told him to compromise the matter. So anyway, he did not agree. We gave 5 lakhs, then National Commission after it was different thing. But the doctor was not agreeing. No, I can't pay. He was an ordinary small doctor. So some things, we do it. Some will succeed, some will not succeed. Now coming to the subject, everything has been said. The main object of this 2019 Act, as has been enshrined, is this 1986 Act was there for more than 33 years. Nobody could find fault with it except for the delay part and the advancement which science and technology did. For that, the Act cannot be blamed. See, with the passage of time, a lot of things will come. Everything need to be changed because law is known to be flexible. If the law is rigid, we can't function. We have to be flexible. Every day new challenges come and every day legislators have to meet that. So therefore, after 33 years, they thought that these consumer markets, for goods have undergone drastic transformation since enactment of this Act. The modern marketplace contains a plethora of products and services. The emergence of global supply chain, here this is very important, global supply chain. In our days, we are not, just now Madam was saying about pens and all that, we are not, we have to go to stores and get them. Now sitting in the house, at the click of the button, you are getting everything. Everything you are getting a click of the button. Rise in international trade and the rapid development of e-commerce have led to new delivery systems for goods and services that are provided for. Here again, I will give an example. I had one case of Amazon's. See, Amazon and all these people, what defense they take, they say we are not the service providers or goods providers, we are only platform. We only provide a platform for a manufacturer and a consumer. Both of them come together and only will do that. Thereafter, if something untoward happens, we are not responsible at all. Completely, they are raising their hands. In every case, they are doing the same thing. Now, I think it was Supreme Court matter pending on that. I don't know what happened. When I was there, matter was pending on Supreme Court whether this platform, providers, whether they can be made accountable. Because I did one case, where a golden biscuit was ordered from Shoppers Plaza at Begumpet. I threw a Bangaram biscuit order instead of biscuit, they got some soap. That is common. And now, when the case was filed, the supply, that media direct was something, not Amazon or something. They said, we don't know, sir. The people gave the packet. This consumer ordered it, 1,38,000 in those days. So we just pasted our stickers and delivered it. Now, who is responsible? There. Yes. So one thing. No, there is a common thing, Keshav. The problem is, so in that case, what happened? That purchaser was very smart. He video recorded the entire process of opening the cover. Otherwise, I took the consumer to task. For 2 days, I scolded him. What an idiot you are! What a fool you are! I said, I think if you are having hard-earned money, you will go to a goldsmith shop, you will get it tested. What is it? No, so some discount was offered. He was from Varangal. But one smart, intelligent, entire process of opening was done video recording. So when we have seen the video recording, I was convinced that fraud was played upon him because when it was beautifully packed. Somebody was saying about that. A beautiful pack, smooth cloth inside, beautiful box outside. Everything was very attractive, but inside nothing was there. Only invoice copy and that. So therefore, this middleman has to be, a strict responsibility has to be determined. I don't know what happened to Supreme Court case, it was pending. All these Amazon, Flipkart, they say our responsibility is not there. Ours is only a platform. We publicize. We say, you want to buy a fan, orders. He will take the order from you, give it to the manufacturer. He will deliver directly. We are nowhere concerned. But where should the consumer go? So equally, this has rendered the consumer vulnerable to new forms of unfair and unethical practices, misleading ads, telemarketing, e-commerce pose new challenges. There also been said misleading ads. If you start about that, a lot of things are there. I think it's in an inaugural session. If you have a workshop, we can go in depth. Next time, if you give me a chance, I will take you all through how we had to. And this 2019 Act. So what is the special thing? Digitalization. Consumer has been expanded. The definition of consumer has been expanded. This is a good thing. There are some good things in the new act. They have expanded the definition of consumer. Even companies can now come under consumer. Otherwise, we used to say commercial purpose. The problem is commercial, not personal consumption. Very thin distinction has to be drawn. Whether it is for commercial purpose or not. Suppose I buy one car and sell the car as it is. As it is commercial. But suppose I buy the car and run it as a taxi. It is commercial purpose, but still he is a consumer. See the distinction. Even he is livelihood, sir. Even selling car also is livelihood. Even Tata Birla is earning livelihood. Ambani is doing for livelihood. Adani is doing for livelihood. Everybody is for livelihood in Atlanta. Who is not earning for livelihood? Even I am earning for my livelihood. But the thing is, if you are selling the product in the same condition in which you brought, without in any way doing with that, then it is a commercial. I used to interpret like that. Some of the cases were upheld, some of them are pending. If you use it for commercial purpose, general problem will be Malgis would take shops and Malgis, the dispute will be there. Because shop is let out for Malgis is let out for shop. It's a commercial business, but I want rent. Rent is for my livelihood. So whether it's commercial or not. So these commercial transactions and consumption transactions are there. They're always debatable. It differs from case to case. The facts have to be very meticulously analyzed for determining as to whether he comes within the ambit of a consumer or has to be non-suit there. Then other thing is jurisdiction. I already said. One more good change is this enabling the consumer to file the complaint at the place of his residence. Previously, this was a very serious drawback in the 86 Act. Previously, the victim has to go in search of the perpetrator. Very obnoxious provision. I have suffered. I'm a poor man. I purchased the small product here and I have to file a case against, suppose some company, iPhone company or whatever nonsense. I have to go to their Bombay office where their head office is there and file the case. Who will do that? There is nothing but exploitation and suppression. But now they have changed it. In this new act, at the place where I am residing, irrespective of the fact as to where the product is brought and where the product is manufactured, product is sold, I can initiate the procedure. It's a very one good change. So the consumer is now saved of the trouble of going to the place in search of the perpetrator. That's one good change in the new act. Then central CCPA is there. Of course, some problems are there. We'll see. Hopefully, it will do a good job. Then product liability. They are all you can discuss in the detailed thing. Unfair trade practices. We can tell our story on that. Then dispute mechanisms. One important thing which I would like this August gathering to debate is execution. In all of you are from senior legal profession, you know the age-old adage. Gelchina court law. The man who succeeds in litigation will smile in the court and cries in the house. So that problem is there. See, obtaining a decree is very easy, but execution is very difficult. That is the story with the civil litigation. Because in my experience as a judicial officer, I can say the man who is perfect with Article 21 CPC, is a master of civil procedure code. Execution side, like you are perfect means he's really a great man, I used to say. Right from Rule 1 to Rule 109, sale laka. If you conduct one sale under Article 21, you are really a great person. So much complicated. I used to say Article 21 itself is a code by itself. Article 21 CPC execution. So what happened is, unfortunately, I don't know how they brought it. In this new legislation, they said you must follow the procedure of Article 21 Rule CPC, the CPC. You see section 72, I think. I don't know what was the logic behind that. Previously, It was a summary procedure. We used to call the person who was violated criminal procedure code, summary trial. Give him copies, tell that this is a judgment against you, you have failed to implement that. What do you say? If you can offer a justifiable ground for non-obedience, non-compliance, okay. If you cannot offer any reasonable ground for non-compliance, we used to frame a formal charge, mark documents, and send him to jail for 6 months. I've sent that Gharanda builder for 18 months inside. Gharanda famous builder. Then that Sandhya conventions, Sridhar, we have sent them to jail straight away. But now, if Order 21 is to be followed, where is the end? Even after obtaining the order, if the opposite party is not honest and does not want to satisfy the award, what has to be done? So I request the authors gathering to debate about this issue and say something about that, because unless execution is effective, no purpose, sir. Each one of us know about that. What is the point? In fact, one day I was sitting in the court of Justice P.H. Chaudhary. Justice P.H. Chaudhary is a great man. Decree for restriction of conjugal rights was given. Then the husband was asking, what should I do with the decree? He discovered it frame just put on. See, restriction of conjugal rights decree ending. He was asking, I was stenographer at that time. If the decree M charge this way frame just put. So such decrees are there. There's no point in giving such decrees. I think law is well settled. No court should pass any decree which is unexecutable. Any decree which is unexecutable should never be passed by any competent court. If you find any difficulty then and there, do some other alternative method, but never pass a decree which is on the face of it, prima facie, unexecutable. I think Sharma have taken a lot of time. Another 2 minutes. It's all on again, disadvantages. And these consumers, I think you are saying that recent data. This 2024, I'm told, is going to have 57% new consumers. You would have read in the paper some data by World Data Lab. 57% of new consumers are going to come from India and China only, worldwide. So consumer market is going up. I always say, often I think you might have heard me somewhere, he is the king. They say, it's not an ordinary idiom, it's a fact. Consumer is the king. You exist for the consumer, not vice versa. It's a cause of repetition, I can say, if they on fine days there are no consumers, where will the Tata go, where will Ambani go, where will Maxwell go, where will they go? So consumer is very important for us. If you won't take care of the consumer, if you won't take care of his interest, then what is the point? So this consumer is going up. Now all this came after this COVID-19 pandemic. After that only a lot of changes have come, transformation and all that. So for a consumer, he's a poor man. We are all salaried people. I think some of you are salaried here also. The salary comes like a tortoise and goes away like a rabbit. It comes slowly, but jumps away like a... So we belong to that category. So for us, we have to be very careful. I think bank frauds. I'm telling you, brother, please kindly pardon me. As a judge for 5 years in State Commission, I had the good fortune of dealing with a vast number of cases. And I request Sharma to give me an opportunity for 1 day. One full day I want to sit with you and share as to how the cases came and how we used to handle them. Because there's a practical side, brother. There's no point in saying the provisions of the Act. I can give you thousands of examples, where how consumers were being deprived, particularly builders' cases that are horrible and Bobby. Tears rolled down even our eyes when we used to hear the plight of the person who brought flats. Headline and one side EMI started, one side paying rent. 80,000 EMI because high end one flat was 2 crores and all. He is paying EMI of 80 lakhs, 80,000. He is paying 50,000 rent, and the building is not even roof level. And who is to be blamed? I open court, I used to tell them, I think all of them Telugu. I used to give an example. Arundhati Nakshatram. Arundhati Nakshatram Atlante, Penli, I think Arundhati Telugu, comfortable. Penli, Penandikala got down to the budget put. అప్పుడైతే తీసుకుపోయి పాప అమ్మాయికి అబ్బాయికి అది కూడా నక్షత్రం ఉందంట. ఆ అమ్మాయి కదా ఉంది చూశానంటది. సో అట్లనే మీరు కూడా అక్కడ ఫౌండేషన్ ఉండదు, ల్యాండ్ మీద ఫౌండేషన్ ఉండదు. ద బిల్డర్ విల్ టేక్ యూ అండ్ సే యువర్ ఫ్లోర్ విల్ కమ్ దేర్. కనిపిస్తుందా? అక్కడ వస్తుంది ఫ్లోర్, హవా మహల్. In fact, one case at Kukatpalli I dealt with. I'm sorry, if you start about telling cases, you know, there's no end for that. And ఆ కుకట్పల్లి ఒక ఫ్లాట్ ఉండే అపార్ట్మెంట్, మొన్న వర్షాలు వచ్చినప్పుడు మొత్తం నీళ్ళతో నిండిపోయింది. The entire area was submerged in the water, recent rains. So they came, all the came as builders. I said, you change the name of the building, you make Lake View apartment on it. 24 hours they are saying it. Okay, gentlemen, I'm sorry, I think I have taken a lot of your time. I was a bit carried away. I may kindly be pardoned. I may kindly be pardoned if I hurt anybody. It was purely for the so this thing. I wish all the best. And again, I request Sharma to give me one full day. Thank you. Why it is not successful? Because a person having good practice will not offer his services, even though Article 33 or 34 Constitution, Article 39 mandates. Article 39 mandates, but nobody is coming forward because, see, who has got the time? Nowadays, everything revolves around the money. Unless money is offered, they won't come. In fact, while I was the principal teacher of Rangareddy, I gave training for mediators. That started at the time. I was 2011, I was the principal teacher. So we were training the mediators. So they were asking only one thing, sir, how much you will pay? Then I was called to the High Court for a meeting. Justice Madan Lokut was the Chief Justice. Then confidence was like this. Then he was saying, what, Mr. Jaiswal, what is your opinion about the mediators? I said, sir, unless you fix some fees for the mediator, I think Brunda Act rules are there. Huh? At that time it was not there. My lord, nobody is coming forward to give any services. Why they will do free? Then he said, Jaiswal, only those are service oriented, society oriented, they will only come, you take them only. They say so many things. So this redressal mechanism, success kavalante, NGOs ravala. NGOs who really service oriented, those who really want to help the society. There are so many. Law teachers also have to come, they will do something. Where
recognized as experts. They have mentioned associate professor, lecturer, they recognized the first time. Thank you, sir.
Thank you so much, sir. Thank you, sir. And now I'd like to request Professor K.V. Sharma, sir, to present sapling to Professor Vidyulata Reddy. And that's a beautiful sapling. And resource kit. I'd request ma'am to deliver the vote of thanks.
You did not tell me. So good morning to all of you, the most respected delegates of today's workshop on critical analysis of Consumer Protection Act 2019. We had a very wonderful inaugural, I believe, definitely. and more especially very good gathering, meeting all my old teachers, colleagues and friends. And more than that, coming to I firstly thank our Vice Chancellor, Professor Sri Krishna Deva Rao, for delivering the inaugural address and taking us back to the discussion even on Donegal versus Stevenson. Today there is a movie made called Kida Kola, which is available on Netflix, made on the basis of Donegal versus Stevenson. And I think the introduction of mediation in the Consumer Protection Act definitely requires a thorough discussion in this workshop, because there are pros and cons of the same thing, whether the consumers will outsmart the corporates or whether the corporates will outsmart the consumers is definitely a question. The reason that the corporates were really too much professional marketism has entered in such a way that consumer protection had to come up through the UN General Assembly guidelines to counter that professional marketing and all that stuff. So that mediation, whether it would be able to address that, whether 2019 Act and the mediation provision in the 2019 Act was successful to counter the corporates or not. As legal academics, it is our job to review it and submit the report to the government and suggest any future changes that are required in this amendment. I think that is one aspect that the sir has raised, and I thank him for giving that valuable suggestions. Coming to Sir Venkat Rao sir, I thank him for coming all over from Goa for making it, and sir is definitely the leader of legal academia today, having served the leading law school and then now serving the international law school. I think under his guidance, the more legal education will see the light into more newer heights. And he has given very pointed discussions that have to be raised, whether the right to repair and more especially whether online medical counseling and whether the medical negligence jurisprudence that is developed by the Supreme Court under the Consumer Protection Act will be able to address the online medical counseling is one thing which we need to look at it. And the e-commerce, more especially the act itself came for the deficiency that it had in the previous legislation, which was not handling e-commerce, whether the jurisdictional issues which were very challenging, the very extent of the the jurisdictional challenges that arises from the e-commerce, because there are a lot of foreign companies, MNCs and whatnot, wherever they are located, they have been doing commerce, and the kind, as Shashikala ma'am said, during COVID and post-COVID, the one market that has heroes in the world is e-commerce. Whether our Consumer Protection Act is capable of protecting our consumers in this digital era is one thing which need a thorough discussion, as Sir has pointed out. And I hope this conference will definitely deliberate on that. And coming to, I thank you, sir, for the valuable questions, pointed questions, which we want the workshop to take up. And I hope the workshop will address that. And I thank Madam Shashikala Gurupur, and she was our old friend, was in our general council. And I thank her for coming all over here. And very interestingly, she has touched upon a point of my interest as well, whether climate justice and sustainability and the consumerism, whether sustainable development goals and the consumerism, what is its link, and whether the consumer, whether green consumerism, as we call it, whether green consumerism has actually influenced the markets as much as it should, or whether the consumer movements or the green consumer movements were not sufficient to counter the markets as much as it should. Like, as I said, yes, the waste management is such a serious issue. Just to give you a record and just to have a think, I would like everybody to think for just 1 second. Every day, Hyderabad alone generates 6,000 tons of solid waste. Imagine 6,000 tons would look like what? 6,000 tons. And there is mountains of waste sites in Auto Nagar, Jawahar Nagar, our neighbor near Shamirpet, Jawahar Nagar, and in other places. So solid waste is such a major issue, and packaging waste in itself is another major issue. With the e-commerce and e-trade, the packaging waste is emerging as one more major problem within the solid waste management. And whether the, she has talked about more pertinent question about social audit of the legislation. When we are doing,
what is the methodology that we are applying for conducting such social audit? Is it really authentic for us to make that when we are giving suggestions to the government? Is the suggestions really well audited with the proper methodology? So we need to work out on those methodologies and yes, Johnson Baby oil and Johnson Baby soap thing is really a worth case study for all of us, because it was banned in some countries. In the country where it is manufactured, it is banned, and in India it is so. Through e-commerce, every child is being purchasing many of them. And there are studies to substantiate that the generation of children who have applied these Johnson products have been more prone to cancer, or the studies have substantiated it. And the corporates definitely, they have their own ways to outsmart it. They said that some changes are made within the products and all that. So we don't know. So thank you, ma'am, for raising very important questions. The question of thinking consumers as a homogeneous group itself is very challengeable question. So the locus standi of the homogeneous group or anybody which the Consumer Protection Act itself is very revolutionary legislation, because it challenges the locus standi jurisprudence. NGOs can file. It challenges the time-bound delivery of justice, the judicial delay. It challenges the composition of the judiciary itself. It says laymen can be judges, and our Supreme Court in VP Shanta very clearly said laymen's sense of justice is far superior to lawyers, because they are always entangled in the legal technicalities. So all these questions, very interesting studies can be made, and I think this particular conference will deliberate on that. Thank you, ma'am, for taking all of this, and she has touched upon very, very many interesting topics which could be deliberated. More than, I think she has given ideas for further researchers, further PhD topics, and for further workshops to be held. And I think Professor Sharma will take it forward under our ministry or chair being provided by the Ministry of Consumer Affairs at Nalsar. So that's the one. Now, I thank her for her valuable insights into this. Now, I thank Justice Jaiswal sir, MSK Jaiswal sir, who has been a pillar of support for all the activities that the Consumer Affairs Chair has been taking up at Nalsar. Thank you, sir, for giving a more insight into the practical aspect of it. These workshops are essentially intended to bring multiple stakeholders and multiple viewpoints and universal ideas from divergent groups, so that each of us can learn from each other and build from the strengths and weaknesses. So as you said, lack of IT support and lack of human resource support is really something really heartening to hear from a state consumer forum president, that this is the pathetic scenario of our justice delivery system, is something which needs to be addressed from wherever pressure can be built, whether academia can build that pressure, whether our workshops can give that guidance. Whatever little we can do, I think the workshop will definitely address that. And your opinion on mediation, let us see whether the 2019 Act's mediation, how successful it was, how not successful it was, what are the intricacies within that could be deliberated on. Thank you all. Thank you one and all. Very enlightened and eminent gathering we have, and I hope the workshop will see very wonderful discussions in the day to come. Thank you all.
Somewhere we teach as a one module, but it's a better take the experiential learning as an example. If you devise a consumer clinic course, that would be the best part. With the 2019 and this 2023 Mediation Act, I would encourage, and we will try to develop a small consumer clinical course. We would be happy to share with all the law colleges. Think about it, but that's where you learn, because the 2019 and 2020, yes.
That's a very interesting point. The Bar Council in the year 2020 had sent a circular to all the law colleges and law universities to make mediation and conciliation a compulsory subject to be taught. And in that syllabus, at page number 9 in the first paragraph, there is a reference to Consumer Protection Act and regulations. This will be in tune with that.
think about it. I think we will help you to give an idea how it should be, when it should be. Next year, second year, to the 3-year course, think about it. But that's a best way of learning, whatever it's overloaded. So many production which is available. How we get experts is there. First time to get. I don't think any other law so far in India has recognized in the legal section the expert can get. They mention about professor, associate professor, and assistant professor. They have got 5 years, 10 years. How the legal academy can designing a clinical, then connect with the destination, connect with the destination, bring the mediator, bring the expert, learn together. That's maybe we will train through that. We will in fact motivate the students to come into the legal profession or become experts in this something. Yeah, I leave in this thought.
Thank you so much, everyone. We have a tea break. The tea is arranged in the lawn, and we'll also have a group picture. So maybe we can all assemble in the lawn for the group picture before our professors take a leave.
Let's join for tea, sir.
Yeah.
One by one? हाँ, right. Shall we start, sir? It's okay. कोई बात नहीं. कुछ लगेगा क्या? They'll present it. All right. So they'll all be seated here. Right, sir. All right. Good afternoon, everyone. Welcome back to the workshop. We are starting the first session for the workshop now. It's titled as Protection Against Defects in Goods, Deficiency in Services, etc. The session is going to be chaired by Professor Rajendra Prasad, former Vice Chancellor, Acharya Nagarjuna University, Professor of Law, Geetam University. So I request you to please be seated. I would request Professor K.V. Sharma, sir, to present a sapling and a resource kit to Professor Prasad. We have, thank you so much, sir. We have with us Dr. Anita Rao, Director, School of Law, Geetam University, as the co-chair for this session. I request ma'am to please come and be seated here. And I request Professor Sharma to present a sapling and a resource kit to madam. Thank you, ma'am. I've announced. Please present the sapling to madam. So welcome gift and a resource kit as well. As the speakers of the session, we have with us Dr. Santosh Kakade, in charge President retired, State Consumer Dispute Redressal Commission, Maharashtra. Is currently working as the Professor of Law at MNLU, Aurangabad. So please come and be seated here. We also have as a second speaker, Shri Murali Balasubramaniam, sir. He's an industry expert in the area of consumer rights and protection. I request Sharma, sir, to present a sapling and a resource kit to Dr. Kakade. I request Professor Keshwar Rao to present a sapling and a resource kit. I am going to. Achha. All right, that's what. So I request Professor Keshwar Rao to present the sampling and the resource kit to Shri Balak Subramaniam, sir. And additionally, I also request Professor Keshwar Rao, sir, to be the speaker for the session. Sir is an adjunct professor at Nalsar University of Law, Hyderabad, and he has been the former Vice Chancellor at NUSRL Ranchi and DSNLU Visakhapatnam. So with this, we start the session, the first session of the workshop. And the first speaker all right. So I request Professor Rajendra Prasad to take up the session. And all the esteemed professors and resource persons are requested to take up 15 minutes for delivering their content. So we have additional mics as well. We have this mic, that one, and this one. All right. You can speak from wherever you want. I can fix it up.
This direction was better. I know it was not very convenient because you face everyone.
Right.
Recording.
You want to Yes, अभी तो कोई बैठा नहीं है खाली
Respected panel members, Professor Anita Rao, Director, Geetham School of Law, Professor Dr. Murali Subramaniam, and Professor Kokadi, and my senior colleague, Professor Keshav Rao, our mentor, Professor Aranget Rao, Professor Sejkala ma'am, and Professor Hemalata Devi Garu, and Dr. Murthy from Consumer Group, and the co-director of this seminar, Professor Sharma. So in the first session, we have very good extensive discussions on many issues. But what we found, the learner speakers talked about many theoretical applications with reference to consumer issues, and also drawn the difference between these law in books and law in practice. What Professor Pound rightly said, law in the books is different from law in action. But the issue that is before us, then it is the case where theoretical discussion is of any use. Very recently, I have seen an article published in Harvard Law Review where it has been said, what is the benefit of, just analyzing all these theoretical issues with reference to a legal problem? What has been said, theoretical application, theoretical discussion is very much important. And also they refer to saying that when you want to have some sort of a beautiful and huge building, at the ground level, what is actually doing is the architect's plan. Architect has to give the plan on this plan. You can raise huge buildings. So that's why just here the section is, and the speakers focus on both the theoretical issue and also practical aspects of consumer legislation. Needless to say, when you talk about the practical aspect of this consumer protection legislation, just what has been said, long back by some critics, a legal attempt to make some sort of a legal attempt to have some sort of the consumer legislation is nothing but like a fly paper attracting the insects. They said legal attempt is useless, but it made a reality and have some sort of a wonderful legislation that has been made by the Indian Parliament in 1986. No one doubts about this. He must be knowing what was the protection that was extended before 1986. We totally relied on these traditional laws, nothing else. And some people, talked about saying there was some sort of this the Sale of Goods Act and contract law or other drugs and cosmetics, many legislations we have. And also it has been said that the criminal law, contributed much for the development of consumer law in India. But leaving aside, when we talk about the the Sale of Goods Act, what has been said, Sale of Goods Act extend the protection only to the buyers and not the consumers. You must be knowing there is a distinction, a legal distinction between the buyers and consumers. But when we talk about the Donovan versus Stevenson just extend the protection just only these to the buyers, to the users, and they need not be a buyer. So that's why the manufacturer ultimately responsible to the consumers, what has been Lord Atkin in that particular judgment held in 1929. But the issue here is whether the legislation that is made by this Indian Parliament is that much effective. Because many people talked about saying the old legislation before making the legislation in 2019, the old legislation is some sort of very, effective and need not to make any changes. The honorable judge also point out saying that the changes that are affected just in the 2019 legislation make, some sort of this amendment to the extensive practice of appointment of the members to the consumer fora. But many things we can talk about as far as the issue is concerned, as far as the consumer issues are concerned. As I said, the buyer's interest, the consumer interest, all these issues are, dealt with by this wonderful legislation that has been made in consumer, in the recent legislation 2019. But here our focus in this session is about the defect in the products and the deficiency of services. So the ambit of the consumer is extended. The ambit of the because of the inclusion of these, two important grounds. That is about these defects in the goods and deficiency in services. But the issue is about, and what I have seen by going through all the, the development that took place after 1926, the consumer legislation has totally or legally has brought out some sort of the legal revolution in India. So this, no doubt it is some sort of a sweeping legislation which you are making. It brought out some sort of the legal revolution. What legal revolution brought in? The legal revolution, nothing but providing easy access to nothing else. This objective of the legislation to provide some sort of a simple justice, speedy justice, and also cheap justice. So that's why it needs all the people just only to think about first the consumer legislation. I want to draw your attention just one of the instances I faced. 10 years back, a person with some sort of a rural base approached me for some legal advice on consumer matter. I asked him, what is the problem? Sir, I have some sort of a consumer problem. I want to go to the consumer court and can you advise me? So he was feeling shy to express the problem to me. So said, don't feel shy. Just tell me what is the problem. Sir, I have the problem. I want to give some sort of divorce to my wife. Can it file it under the Consumer Protection Act? Whether divorce can be filed in the Consumer Protection. I laughed at it by saying that, is it possible? It is not possible. Sir, somebody told me there is a clause around deficiency of service. I am complaining of the service of my wife. On the basis I wanted to file it. She is laughable. But you can also think about the mind of an illiterate. Just only to think of filing the cases under the Consumer Protection Act. Just honorable judge also, talked about saying that there are many huge pendency free cases, before the consumer fora for redressal. So that's what is the reason for that? You not to pay only you not to pay at one time. Now you have to pay only the nominal fee to come to file the case before the consumer courts. So I likewise don't need to engage a lawyer. Now, just under the Consumer Protection Act, to the recent legislation, you can also file. You have the access to these consumer flow through e-filing. So that's why we provide some sort of easy access to justice. So it made all the people, whatever may be the problem we have. Now, first you are thinking of going to the consumer courts, then filing. A case in the regular courts. This is evident. Everyone knows about this. So there are many evils of the legislation. The litigation in the regular civil courts, worldwide. So it is not an exception. A wonderful report long back submitted in 1995 in England by Wolf. Lord Wolf has, submitted a very wonderful report about the access to justice. He referred about the evils of civil litigation. But when you come to the consumer legislations, the legislation, what we can witness is, and so all the, there are no legal barriers to approach these, the informal fora. So the informal fora is generally be preferable everywhere. So that's why here, I mean, just the consumers are preferring or everyone is preferring whatever may be the issue. That's why when you see about, I mean, the classification of the cases that have been just filed before the fora and just it touches all many sectors. So the issue is about when you talk about the definition of, sorry, the definition of service, which is one of the ground the Consumer Protection Act. I mean, it has, I mean, expand the ambit of this, I mean, legislation. And as I mentioned earlier, there is no exclusive or a special legislation focusing, I mean, inviting the cases under the different legislation. But here, just to be included the service sector within its habit, it has been said that this expansion is much needed because the economy. So the economy of any country nowadays, I mean, rests on only the service sector, and India is an exception. It has been said the service sector contributes more than this 50% GDP in India. So that's why more focus is on service sector. When you are more focused on service, naturally it may lead to more litigation in this area. And only the, redressal for the judicial dispute resolution available to the, the users of these services, only the consumer for nothing else. So that's why what what I'm trying to say is these definitions of service, especially the definition of service, has been aptly defined under this Consumer Protection Act, even though the definition is very wide. But I wanted to bring out some sort of a very good distinction that has been pointed out by a Japanese scholar long back, say, I mean, the 20 years back, I mean, between the services and the goods. A very nice distinction that has been made. What she said, I mean, as far as services are concerned, you can't filter as far as, I mean, this quality of the services, and you can't store them. So, I mean, as well, like, I mean, these products or the goods. And also, she highlighted by stating that, I mean, here, this producer is also part of this product because it needs the personal relation between the service provider and also the service seeker. So that's why there is some sort of personal relation that is with reference services. And also, as far as the value is concerned, so as the linkage between the cost and value, that can't be, assessed before availing the services by the person concerned. Because you must be knowing that there is some sort of an IS mark that has been awarded to the goods that are produced, but you can't give an IS mark to the service providers. So that's why a very interesting distinction that has been made by the scholar with reference to these two, sectors. So, when I talk about this, another important one is about this defect of the products. So, whenever you talk about the products, what are the defects that are present in the goods, just that are also brought within the habit. The definition of good is some sort of vague, and the draftsman itself, asked us to go through the definition of these goods under the Sale of Goods Act. So it is very wide, very vague, and so the issues it does not include many things. So what has been said that whenever there is a defect in the product, what is the remedy that is available for the consumers? So, and you are a buyer. Okay, well and good, you can sue under the Sale of Goods Act. So, and suppose you are a consumer of the goods, where you have to, knock the doors for justice. So that's why here the only law that has been left for these consumers is nothing but the Consumer Protection Act. So earlier, there are the criminal laws that can be invoked to make the manufacturer goods the liable for the defects in the products. Again, they brought some sort of distinction between what is meant by defect, whether this manufacturer is responsible for all the defects in the product, only certain defects. So it has been said he will be made responsible only for this patent and not the latent. So when you go back and see the Donor versus Stevenson, when it has been highlighted, sorry, the analyzed by the foreign scholars saying that, so as far as the liability of the manufacturer in that case is concerned, because this decomposed snail is visible in the bottle that has been supplied, in the ginger bottle that has been supplied, and will not be responsible for any inherent or unknown defects. So the knowledge of the defect is very important as far as to make the parties liable under the Sale of Goods Act. Even that can be applied with reference to this Consumer Protection Act. The first one is about the knowledge of the defect, and another one is, and as far as to make the manufacturer liable as far as the defect in the products is concerned, whether you have to see the conduct of the parties or the manufacturer or the condition of the product. So we never see the conduct of these manufacturers, we will see only the conduct of these manufacturers, we will not see the condition of the product. But as far as the law, as far as this law of torts is concerned, it will see the conduct. It will see the conduct of the party to make the person liable. The reason will be, it has been said, you also see not only the condition, but also the conduct of the party responsible for liability. And this is nothing but the application of strict tort liability as far as these defects in the goods are concerned. So can you apply this strict tort liability as far as the services, services sector is concerned? But when you see, the 2018 legislation, it is said it is some sort of the ambitious legislation, nothing else. He included many things and dumped it and saying this is very, extensive legislation extending the protection of the consumers, very ambitious. So, at one time in England, the Pearson Committee refused to extend the application of strict tort liability for the deficiency in services. They said only the strict tort liability is applicable only to the defect in the products and not for the deficient services. But here, what has been said that the draftsmen or the policy makers, extended, the product liability law even to these deficient services. And that's why I said there are many defenses that can be raised by these, the manufacturers, to avoid the liability. So to what extent? Because just inclusion of the product liability, you can also make a separate law for the product liability. Why you have included? So that's why I said you have dumped it and included many issues, and also said the mediation that also being done as far as the disposal of the cases, many things. So that's why the speakers in the previous sessions showed the bulky, Madam Shashikala also drawn our attention saying that this is a very lengthy legislation that has been drafted by the policy makers. So legislation must be very simple. So one thing, this, the consumer legislation is not only for the illiterates, it is also meant for the illiterates. So that's why the legislation is such of that big or voluminous. So how this, the poor consumer, layman can understand all these legal, just jargons. So that's why, what I repeatedly saying that these, the ambitious legislations. What I said, no need to amend this particular legislation, making some sort of, just in new legislation is nothing but, generally we're saying that a old wine, new bottle with new label, nothing else. Because as far as the consumer jurisprudence is concerned, under the old is 1986, all the rules are well settled in many decisions. I will tell you one of the cases for the deficiency of services. This is also a very interesting case that has been decided by the State Commission of Orissa. What has been stated in that particular case is, a client approves the consumer for alleging that's the case that is pending in the regular civil court is unnecessarily dragged by the judge. Already filed a case in the regular civil court. The concerned judge, could not dispose of it for various reasons. It was delayed so much. Then the client, the litigant, filed a case under the Consumer Protection Act to make the judge responsible for the delay caused for not disposing this particular case. Is not interesting, because what is the ground just he raised, that is the deficiency of services. So that's why whether the judges are amenable. the issue that has been Professor Venkatrao Garu, I mean, all the professors are liable, why the advocates are excluded? Need not be. Likewise, I mean, at one time when the act was made in 1986, there was some sort of application from the medical profession to include their profession under the Consumer Protection Act. Because you see, this definition of service under section 2 of the old enactment, what has been said, many professions, all the professions are excluded, but there is some exception that has been added to section 2 of the definition of service of the old legislation. The people, I mean, who render the service under a contract of personal service, they excluded. So doctors, I mean, base their argument saying that we rendered our services is nothing but some sort of, I mean, a service under a contract of personal service. So that's what personal means. So because the client will come to us, we personally, I mean, inspect them and also consult, I mean, just render the advices basing on personal consultation. So that's why we should be excluded. So that is the doctors, I mean, just defense. But the Supreme Court of India clearly laid down by stating that doctor services will come under the purview of the Consumer Protection Act. When they relied on this contract of person, it is not a contract of personal service, it is a contract of professional service, nothing else. Apply the same analogy and all professionals are, I mean, included in the Consumer Protection Act. But there are many instances where there is, I mean, difficult to decide the cases because there are some sort of, I mean, amendment that was made in 1993 to the Consumer Protection Act. So one of the very important judgment that has been given by this apex court saying that legal heirs of the deceased patient is also a consumer. Legal heirs. So you see how they, I mean, expand the horizons of the consumer protection. What my just anxiety is, just to inform you, no need to make this legislation a separate legislation, repealing the old legislation, making a new legislation, making it very bulky, making, I mean, including many legal intricacies need not be. So we never find fault. This is a legislation meant for the poor consumer, nothing else. But I mean, just we must see, I mean, what will be the outcome of it in near future. But before closing that, I wanted to just only bring out some sort of challenges that should be resolved, that should be discussed. The first one is about the liability, legal liability and the Consumer Protection Act. I also mentioned about saying that, I mean, whether is apt to include this service sector under the regime of the product liability. There are many developments that took place in Western countries, especially England and the US, as far as the product liability regime is concerned. We borrowed it. So in nothing but legal transplantation, we just only borrowed it and also, I mean, included saying our legislation also, I mean, just focusing on the latest development, I mean, this as far as the consumer issues are concerned. Second one is very interesting, very important, as far as the liability, when you talk about the liability and on whose, responsibility, the burden of proof lies. So as far as the consumer law is concerned, the burden of proof lies all the time only on the plaintiff. But I mean, is it possible to a poor consumer to prove the medical negligence of a doctor? Suppose he has undergone some sort of a surgery, and how can you prove that doctor is, I mean, negligent while conducting such operation? That's why there is some sort of Western countries saying that there must be reversal of the burden of proof. That is the need of the work. I mean, it will come to the rescue of the consumers. And the next one is about the inducement. I attended a conference in South Africa just only, I mean, 10 years back. They talk about, I mean, the credit cards and nothing but some sort of inducement. Especially, we also witness about, I will take only 2 minutes just to, I mean, conclude my opening remarks, nothing else. So, I mean, as far as this credit, cards usage, and these, I mean, the consumers, these holders of the cards receiving some sort of, I mean, request, I mean, also offers from the bankers to take the loan. We also getting the cards saying from the bank saying that you take the loan we offer, I mean, with low interest. Will it not be an inducement until even though you are not interested? But you are induced to take the loan. When you can't pay off, then you are made responsible. There is a wonderful legislation in South Africa. This will do with, I mean, credit liabilities as far as this, phone calls from these, the offers from these bankers. So this also be considered by the, because whatever the investment that has been by the other party to enter into a contract, then you can't be absolutely liable to, just liable under that. So that should also be thought of. And there is emergence of new class consumers nowadays. I don't want to talk too much on this. Madam Anita and Rao, Professor Anita will also focus on this new class consumers. And the next one is about some of the speech touched about the AI. So that's why when you get some sort of a service advisors from the AI, using of AI technology, then who should be blamed? Who should be responsible for these advices? And another very important cross-border transactions. So how to tackle this? Is there any clue as far as this cross-border transactions? As far as some, Professor Venkata touched about this telemedicine issues. So that's why during COVID, just we used to get the advices from, from the doctors online, including from the foreign countries. Now the issue is what about the liabilities as far as these issues are concerned? These are the very interesting issues that are to be discussed. And also, the act should also throw light on this instead of, borrowing the Western principles. And I think we have not seen the Indianness as far as this recent legislation is concerned. It is nothing but borrowed principles, and we have to make, necessary changes for the legislation. Thank you for consuming more time, and I'm concluding with these opening remarks. And now I request Professor Anantarao Garu just to say about his views on consumer rights. Thank you. Taken more time. There is no stopper, sir. There is no stopper for me.
Stop. You wanted to stop.
Can't switch off chairman. नहीं Dharma ji, by 1:30 we are closing.
Because after 3 panels were absent.
Oh,
So we are saving time there.
okay.
No problem. We can complete the program within time.
So I'm starting at 1 o'clock. Oh. Good afternoon to the esteemed members present here. It's a wonderful opportunity, I feel, to interact with many of the luminaries here, and a great privilege. In fact, much has been said right from the morning till from inauguration till now, and very inciting informations have been shared with all of us. In fact, no doubt that Consumer Protection Act and the amendment is the main theme. But way back in 1976, I just would like to give a small anecdote after this. That was the time when I just started my law course. When Professor Gupteshwar was teaching the subject Law of Torts, Donahue versus Stevenson was taught for us, you may be surprised, for 3 months. And he was asking us to read the entire judgment. And it was an eye-opening for all of us. We were thinking that what exactly, of course, the case has been filed, the damages, all this, but never the term product liability, we could never see that in the discussion. And it was always a puzzle for me, till recently, maybe for about 15 years, when the EU has passed the guidelines regarding the product liability, saying that
the manufacturer is responsible for the defects right from the product, production, designing, packing, and all the supply chain management till the consumer. And in fact, it was said that a parallel has been created that a consumer is very, very small when comparing with the manufacturer giant companies. How do they really approach? Is it quite possible? Now, the answer is very clear. Introducing this product liability into the recent amendment, but there is something called the inequitable, or you can say unequal level playing game, in the sense, how do we really end just filing a complaint in the district form or maybe state or national form and sit comfortably? Let the manufacturer be responsible to answer the person where exactly the fault lies. So whether you go ahead with the fault theory or strict liability theory, as we have already known very much, but end of the day, the manufacturer is made liable. That is very clear. Now, taking the clue from the Sustainable Developments 12, where it has said very clearly consumption, production, and protect the interests of the consumers, very rightly it is said that is the endeavor of any country to reach that goal of the sustainable developments. So whether an amendment is required or not, that is a separate discussion altogether. Whether we call it as a new wine in the old bottle or old wine in the new bottle, that is again a separate thing. If the access to justice has been really being given or reaching to the poor consumer, here we call the consumer as poor because he is not on par with the manufacturer. So unless the amendment is really audited in the coming few years, we may not be really have to conclude. We may not be able to conclude whether it is going to really do the justice to the poor consumer. Now, I would like to talk about not about the the amending act and the advantages, the mediations, the liability factors. All these plus points are there. Definitely, it's a revised version and an added version, and definitely a good version than the previous one, because as we rightly say, though the old act was really serving for many years, for almost 30 years, a new act is inevitable because of the inevitable intrusion of technology, too much of technology, e-commerce, and also the other telemedicine after the pandemic. It is inevitable. It is good. There is nothing wrong in having an amendment in that. But the only thing here is, like when you talk about the new act, we have to really look at who are the new consumers actually, who are the probable consumers in the coming years to come. Is it only the consumers who are actually buying and selling the goods, or is it the services or any other thing? See, like for example, any person buying and selling is now branded as a consumer. There is no exception to that, except unless a special legislation is being given to for protection. But here, when you talk about the health sector, especially because of the globalized scenario and cross-border health tourism we are having, too many health issues are coming, and also too many cases being filed against the corporate giant hospitals. And also it is, I'm not saying the hospital is always wrong and the consumer is always right. No, it is not that. Because unless until the strict standard rules of duty of care is being really proved, you cannot say there is a deficiency of service. So just because the doctor took a different opinion about a procedure which is going to be good and acting for the benefit of the patient, you can't claim if even if the patient is not receiving, you can't say he is negligent. There are cases very much reported, and in fact, when you approach a doctor, no doctor say 100% he will be doing the success. It is only a positive attitude. You always say we will try, we will try, we will try. So that doesn't mean since he has accepted the case doesn't mean he is a god there. He will try definitely. Especially when I talk about, my heart always goes to the new technologies, because where these IVF clinics are really mushrooming these days, and where the services of infertile couple are now being taken care by opting these very expensive treatments. may it be a sperm donation, may it may be a gamete donation or fertilization, cryopreservation, or maybe you can even say the surrogacy. So that way, deformities in the entire process, can it be challenged by these consumers who are actually approaching these fertility clinics as consumers and ask for compensation? So this is a good case actually. I was just pondering over this case where the two couple actually they have approached an hospital at Lucknow, Javitri Hospital, for that fertility treatment. And in fact, there was a lot of advertisement for that clinic stating that they will ensure the baby once they have undergone all the procedures. And here what happened is like they charge around 75,000, which is considered to be very, very less comparing the other countries. So very reasonable. 2,000 has been paid for them for the registration. Afterward, they're subjected and any number of tests have been done to the lady. All the procedure protocols has been very much wonderfully has been done. I'm not going into the medical terminology because it's a separate case by altogether. That finally what happened is strictly following all the instructions given by the doctors, and the doctors are also very happy that she has actually been following up all the procedures. End of the day, what happened? She delivered a baby. And finally, when the baby delivered, there was a little deformity, and the deformity is found to be like a TIFA, that is a test, total imaging fertility abnormality of the child. That means they found the child is little abnormal, so they have advised them, the couple, to go to the other hospital for further treatment. And further treatment took place, and finally, the end story of this is the husband filed a case against the fertility clinic, claiming a huge compensation of return of the 2,25,000, 70,000, and 1.5 lakh for the medical treatments, on and so forth. So here, a huge amount has been claimed for. The court here has laid down saying that there is definitely a defect in service here, in the sense not for the fertility, that is as per the procedure she has been conceived, but when there is an abnormality and the sonogram is being taken in every 21 plus 3 days, 27 plus 3 days, 29, it was never been detected, nor they know, but they have not informed the couple. So that way, not informing and concealment of this particular fact to these parents, probable parents, is a deficiency of service, and the court has ordered in this. That means this is a new class of consumers who are probable to come at a very high class, and huge amounts of compensations the hospitals has to really pay. And also similarly, there is one more case in this medical negligence where it is found that, that is also one important high court, Supreme Court case, where it is said there is a case regarding an epidermal allergy. Epidermal allergy suddenly developed by one claimant here. And here, when they have actually done this test, and when they are having no required equipment in the hospital, Breach Candy Hospital I'm talking about, there's a case against the Breach Candy, one of the most famous hospital, they found staffing of the office with the, hospital with the required equipment is again a deficiency of service. So like there are any number of cases you all under this particular consumer protection is going to be really erupted in the future, and this particular branch of study is going to be really prominent in a very high technological assistance. Similarly, the second important area which I would like to see is the protection of consumers due to the violation of intellectual property rights. So this is a new divergent area where, like with the globalized scenario, and where we have actually gone into the fold of multilateral trade agreement, India also is prone to actually has given the promise, and in fact we have compiled with all the provisions of TRIPS agreement. So especially with reference to patents, copyrights, trademarks, especially if you connect with the consumer, is a direct relation with the trademark violations, where in fact we were reading all these deformities and deceptive similarities and advertisements under the Trademark Act, and also like passing of trade, So all are nothing but a part and parcel of the consumer now become consumers. And also geographical indication, take for example, the consumer protection and geographical indications. So this way the information technology, geographical indications, Designs Act, Copyrights Act, Patents Act, all these are now becoming a sort of elite groups which can be clubbed up under the Consumer Protection Act because everybody is a consumer. And to relate it again, we have one more important aspect called the Competition Act. Let us talk about that also, because when Patent Act is being introduced way back for the supply of pharmaceuticals, drugs in the country, where it has been really steeped, in fact, in the global scenario, when the product and patent regime is now very much there. See, what is actually is that trying to protect the market, the global market economy, by giving a sort of protection monopolistic right to the inventor, and at the same time giving an incentive. But here we are talking about the consumer, an individual, very, very small person comparing with the entire global scenario. And also there is a parallel here, the Competition Act. We are actually, what we are doing is supporting a healthy competition here. Healthy competition means you flourish and also it should be healthy. So the consumer should be given a good quality, quantity, purity of the goods for what he is paying it. So that way, I feel that new dimensions of this consumer protection need to be really studied thoroughly. And when you're talking about this recall of goods, like for example, McDonald's and Toyota cars, and number of goods have been recalled back because they're defective in its manufacturing design or product. So these things need to be taken into a clear-cut vision. Just because a consumer is a poor person, he is not low, but a manufacturer is a big, it is not a great thing. So the new act, as far as the calculations are concerned, computation of calculation concerned, you should not go for the calculations as per the Motor Vehicles Act, where the multiple calculations will be done. It is the objective, like whether he is a rich person or a poor person, whether there is a deformity or not, it should be taken into account. That way, maybe some real justice, social justice can be made, and we can really do, a sort of satisfaction to the goal of sustainable development under 12. So I am sure with this few remarks I have, which are not, I think, been covered in the earlier sessions, I thought I'll just share it with you. And also very much thankful to the justice, where he has given the ground realities. It is stunning and extraordinary real. It is extraordinary. And also the previous speakers like Professor Venkatrao Garu, that Sharma ji, all these have given the new dimensions. And also one important factor is the mediation factor, which is amazing really. There are two, one is at the top, the other one is later. You bringing them on the same footing, it may not really work, but we have to yet to see, because this is the newly incorporated provision and yet to be tested. So with these few remarks, I think I'll leave the floor, and maybe as and when required, probably chance may be given to interact with the paper presenters. Thank you so much for this opportunity. Now, yes, the speakers. Thank you.
Next speaker. So the next speaker is Dr. Santosh Kakade. So please. Which file is it, sir?
First one. So good afternoon to all of you. The consumer chair of Nalsar Law University, Professor Dr. TVS Sarma sir,
Then the chair for today's session, Professor Dr. Rajendra Singh sir. The Rajendra Prasad sir. Then Vice Chair, Co-Chair, Madam Anita Rao. The dignitaries who are sitting on the dais. One more important dignitary for me, my PhD guide, Professor Dr. Shishikala Gurpur Madam. Then those whom I had few opportunities of few interactions, like Professor Dr. Venkata Rao, and comparatively recently got introduced to Dr. P.V.V.S. Murthy sir, who is a consumer activist, and the dignitaries who are sitting in the audience. So very small group of, we can say, focused and concentrated academicians. The whole idea and the brain behind all this is of Professor Dr. K.V.S. Sharma sir. At the outset, let me thank him to invite me here to have an interactive session with all of you. At the same time, it's a great learning for me to hear from everybody, from everybody's talk, different perspectives of the same topic they are available. Now, I'm the general and orthopedic surgeon, practiced for 20 years, graduated, post-graduated in law, completed my PhD under Madam's guidance. Law governing medical negligence under Consumer Protection Act was the theme of this particular aspect. Also did 2 MBAs, and then I got an opportunity to sit on this side in the State Consumer Commission as the member non-judicial. Out of 5 years, 4 months, I was the in-charge president of the State Consumer Commission. And my experience is same as our honorable president of course, past president of the Andhra Pradesh State Consumer Commission. The practicalities are totally different, and till today there are nuances for this. Before going ahead with the topic proper, just to share with you, I actually tried to give a presentation to the Central Consumer Affairs Ministry, all the 3 secretaries and the legal team, to what needs to be done, what needs to be changed in the Consumer Protection Act 2019. So this I did in 2019, last year itself. And I blatantly tell right now, as well as I already told, that the justice is not being done to the consumers. Sorry. This is after 5 years of sitting as the member. It's a equivalent position to a judge of a high court. So I shared everything with him, as well as I shared with all the authorities. I visited all 46 consumer commissions of state of Maharashtra as an in-charge president, and brought out what are the lacking things, and of course the infrastructure, manpower, monetary support, everything is lacking in the state of Maharashtra. And I found that it is the same thing which is even in Andhra Pradesh. So just having faith in the system, I shared this with even PMO, my report, I submitted my report of 200 pages with all the authorities. And of course, having faith and knowing that possibly some action will be taken and really the consumer will be benefited. So with this, just a small introduction, I wish to actually talk about the product liability. We have just 10 minutes, and I'm sure I'm going to complete it within 10 minutes. So this presentation, of course, was prepared for medical professionals actually, because I have just modified it for this thing. And lot have been said about the involvement of medical professionals, but since I did PhD in that, I have certain different perspectives of that particular this thing. So medical profession as a service, I can talk for the whole day from morning to evening. But then today's topic is the product liability. The Consumer Protection Act 2019 It's altogether different. It is not an amendment. It is not at all an amendment. It is completely new act. So old act was repealed and new act has taken its place. So this is quite important, and there major changes have been taken place. If you go through the bare act, there are almost more than 50 changes which you will find that have been made. Of course, pros and cons have been being discussed, and many of the points were discussed from the legal luminaries in this particular forum as well. So this was for medical professionals. So I'm just skipping it and just going it to the today's topic as such. That is the Consumer Protection Act 2019. Just a gist of it, the old Act, Consumer Protection Act 1986, had only 31 sections. Now this has 107 sections. There are 8 chapters. Additional inclusion of the Consumer Protection E-commerce Rules 2020. Now, without going into the details of all these chapters, I will just go ahead with the product liability issue. Consumer Protection Councils having just advisory capacity, section 3 to 9, all 3 levels, the councils are there. Central Consumer Protection Authority, of course, this was also briefly mentioned by some of the legal luminary. Sections 10 to 27, a separate mechanism has been created. Of course, pros and cons are being discussed. Then we are going to have the session on redressal mechanism, Consumer Disputes Redressal Commission at 3 levels, the national, state, as well as district. Lot many changes have been actually implemented, rather proposed. Sections 28 to 73. Mediation, a new introduction, section 79 to 81. Mediation, mediator's appointment, formation of mediation cell, and then actual implementation of this particular. So whether it has been the right thing or it has failed, it is yet to be known. Coming to the product liability, which is today's topic, and here sections 82 to 87 take care of the product liability as such. Every product has 3 fathers, we can say. That is, one is the product manufacturer, second is the product service provider, and third one is the product seller. So these are the 3 ones. So at these 3 levels, this product liability is being discussed in this particular act. Coming ahead, I'm just going to point out what are the provisions under sections 82, 83, 84, 85, 86, 87. So, and then I'm going to stop, because then we will be discussing about what the pros and cons of the product liability which is there in the act. And I'm sure you must be aware that it is the bare act or the legal provisions are far more important while deciding any case. The second comes is the judicial pronouncements, that what Supreme Court has said. And then the other as according to importance, the other evidence in the form of documentation is considered. Section 82 discusses about the applicability of this particular chapter, chapter number 6, to the product liability. So every claim under a product liability action by a complainant is discussed under section 82. So either defective product or defective services. Definitions are given in section 2. There are certain subsections which follow from subsection 32 to 38 of section 2 of Consumer Protection Act 2019, give different aspects of the product, definition of product, and then the manufacturer, etc. Section 83, against whom the product liability action can be considered. So here, action for any harm due to defective product. This is the basic key of the section 83, key concept rather. And it is against all these 3, that is liability against manufacturer, seller, and service provider. Section 84, this is quite important. Liability of product manufacturer. Subsection 1 gives the liability when there is a manufacturing defect in the product. Second, when the product has defective design. This is second point. Third is deviation from manufacturing specifications, So the manufacturing specifications are there, and if there is a deviation, this is considered as the liability of a manufacturer. And fourth is product non-conforming with the express warranty. So warranty which comes out with the product. If at all this express warranty, there is a non-compliance with non-conformance with that, then the liability is there. And failure to adequate instructions of correct usage. This is fifth sub-point. Failure to adequate instructions of correct usage, how the product is to be used. So this again comes under the liability. Sub-point 2 is, this is quite important, and I consider this point is to be debatable, and we have to discuss this point in the post-lunch session. Liability, even if the product manufacturer proves that he is not negligent, kindly see these words very carefully, or fraudulent in making express warranty. So even if the manufacturer or the service provider or the third person, surveyor, this one, product seller, they, even if they prove that there was no negligence, still the liability is there. So this is a point which I think we should think about, consider any alternative option we have to suggest, we can definitely discuss. Section 85, liability of product service provider. So in that, faulty, imperfect and deficient service. B is act of omission or commission or negligence, that is considered. C is did not issue adequate instructions on warning to prevent harm. This is again, so liability is proved when the product manufacturer or service provider or seller did not issue adequate instructions or warning to prevent harm. Last point is the service did not conform to express warranty or terms of and conditions of the contract. So I think you all are aware that in the legal mechanism, the provisions in the sections, they are to be proved by the advocates who are arguing on behalf of either this party or that party. I think you are aware of this legal mechanism. So each and every point has importance with respect to the legal mechanism being followed in the consumer court. So this is about section 85, section 86, liability of product sellers. So the product seller can say, oh, I have not manufactured this product, so I don't have a liability. So when product seller can have this liability? So these provisions are given under section 86. When the product seller had substantial control over designing, testing, manufacturing, packaging and labeling. So when he has the control, he has the liability. Second B point is he has altered or modified the product which has proved harmful. So product seller has altered and modified the product which he got from the manufacturer. If this is proved, there is a liability of product seller. Third is he has made independent express warranty, which is different from the warranty which has been provided by manufacturer. So on his own, if suppose he provides, then this is a liability for him. The product sold by him, identity of manufacturer is not known. So product seller is selling the products, but the product liability, chapter number 6. So there are certain exceptions when all these three, their liability cannot be fixed upon them. In that case, I will just read out the 4 or 5 things and then I will stop, because this is the time to think about what exactly we are going to discuss. So exception number 1, exception when the product was misused, altered, and modified by the user, that is consumer. Second point, no action on account of failure to provide adequate warning if. So, if adequate warning is not provided by the product seller or manufacturer, but still the liability will not be on him when a product purchased by employer, adequate warnings and instructions were given. So when an employer purchases a product and distributes to the employees, that time this liability will not be there. Second point, product was sold as a component or material used in another product. So another big product is there. The product is being used for manufacturing of that big product. In that case, all these three will not have the liability. Product legally meant to be used only by expert or class of expert advice. So product, see, I received one product and I started using it, but it is expressly written there that it is only to be used after the expert or class of experts advice. And if I don't follow that, the liability will not be there on the heads of all these three. Then last one is complainant while using product was under the influence of alcohol. So this is very common nowadays. It's a social aspect that we drink, and we also of course follow the Western country because we are now very much advancing, isn't it? So the advancement, see, one of the saying it is said that complicating the simple things is an advancement in the life. Complicating simple things is an advancement of the life. So we are complicating like this by the certain things. So if the consumer is under the influence of alcohol, and of course that is proved by the advocate of that particular this one consumer, the product seller, manufacturer, then yes. Last one is the consumer had knowledge based on his own standing about the product, which is very obvious, which is brought by the advocate of the product seller's advocate before the court, then the product liability will not be there of the manufacturer, service provider, or product seller. So this is a gist of sections 82 to 87. Now this is the main crux which we are going to discuss, and I think we should come out with whether the things are, of course, we are the academicians, we will definitely come out with certain our opinions about how the thing should happen. Now, rather than going ahead, I think I will stop here. Just to this thing, based on the experience of sitting on this side as a judge. Let me tell you, there is a certain need of awareness which was actually brought on, and I must thank Dr. Gurpur Madam, because she had come out with so much excellent new different ideas which have to be acted upon. So one more important aspect is that to create awareness among the consumers, which include we all, and I just actually discussed with Sir Dr. P.V.S. Murthy sir that your efforts need to be 1 lakh times. That means the consumer awareness is the only thing which is necessary to force government, bureaucrats, and also the judges or the members who are sitting on this side. So this is quite important. With this, let me stop here. Let me again thank Professor Dr. Sarma sir for giving me this opportunity and inviting me here. Sir has been, he had been the Vice Chancellor at Maharashtra National University of Aurangabad, and this is developed because of him only, and he is so proactive. He has come out with new ideas, and with his actually support only, we have launched a 2 years executive MBA program for medical professionals and hospital administrators in medical law and hospital management. Our first batch is of 25 senior medical professionals, and that I am actually conducting. I must thank Professor Dr. Sarma sir for giving me this opportunity, giving me this. Thank you very much.
speakers, Murali sir and Keshav sir, will speak after lunch. 2:15 will start. Sir. And after luckily the three guests are missing. They are not coming. So we can calculate more than 5 speakers we have. We can put back. They are not coming. They are likely because I can't stay. I have. Because chief guest is coming, there are chief person, they have to wait. Once they come, 5 o'clock, they end the former IAS officer, retired IAS officer, they have to wait. This is what we can see that. That is not for that. It is all.
Good afternoon, everyone. Welcome back after a sumptuous lunch. Now I request the chair to unpause the session that we have paused and kickstart the session again. Thank you, sir.
I think I'm otherwise pretty audible. Okay, respected chair, co-chair, fellow speakers, eminent academicians, faculty members, and delegates. It's my pleasure to speak on the topic of this session, which is close to my heart. I realize that I form the third part of the stool, you can say, which is heavy towards academicians here. We had a few judges, and here I am supposed to be representing the industry. I mean, I have to start with the disclaimer. I'm not an industry expert. Yes, I have worked for 30 years with Nestle, so I have a decent knowledge of that industry. And normally, industry is the whipping boy in all these sort of forums. But having said that, I think there are a lot of genuine efforts that are made, and that's what I would like to share. And what is the approach we feel could be productive and in a cooperative spirit to achieve the ultimate objective all of us have towards serving the consumer in the best possible way. So the Consumer Protection Act obviously is the main legislation which governs this area. But there are a lot of allied legislations, like there are sectoral legislations, like the Food Standard Safety Regulations. For example, that plays a very big role in this. Similarly, you have the Drugs and Cosmetics Act. They play a role. You have the legal metrology, which plays a role. You have now data privacy coming in, your Digital Personal Data Protection Act. That's going to play a role. So I would say that when we look at an analysis of this, it has to be holistic, taking into account all that is available in this space. And the Consumer Protection Act, I would say in some quarters, is given a very restrictive meaning of a law which allows consumers to make a complaint, and in case their rights are violated, look for redressal. This is the general understanding. That's not clearly the way industry ought to look at it. They must not look at it as something where you are trying to resolve a complaint. For industry, it's about doing business that is in line with the consumer protection law. A dispute with the consumer actually should be the last option. And actually, it's very self-serving. The irony is, in a best case scenario, I go win a case in the court against the consumer, but I've lost a consumer. And that's not the intent of business. The Act imposes strict liability on the product manufacturer or the service provider for any deficiency or defect. And the consumer need not prove that the manufacturer or service provider was negligent. This is a change in the 2019 Act, which is positive. Now that issue of negligence is out of the way. I mean, the fact that I was not negligent doesn't help me. It's an absolute liability in a way. And so the exceptions to the product liability are very limited, which sir just shared with us. In addition to product liability, violation of the Consumer Protection Act also attracts penalties and in some cases imprisonment as well. So while the financial legal consequences of non-compliances can be severe, equally, if not more important, is the reputational damage to the brand and the entity. Also, today, any such news travels like fire. Invariably, it finds itself into the social media, amplifying the issue, and the possible reputational damage actually gets amplified. So there is every reason why the industry would want the consumer to be a happy person and serve the consumer rightly. In the last over 30 years, and you've heard it many times now, I was the chief legal officer of Nestle, FMCG, dealing in day out with consumers. And for us, consumer protection was a norm to be strictly followed. Amongst others, because there are so many compliances. Compliances with consumer law was verified before a product was launched or a promotion was initiated. So, and if there were any changes that were necessary, they were made ahead of the product getting launched or the particular communication going out, because correcting it later is very, very difficult and can be very costly and the reputational damage. So, I mean, now looking at it from a different side, the consumer protection law, the way I see it, has been pretty much keeping pace. Maybe at times lag, but it is keeping pace, and there is also changes coming in that are there. If we can just take, we've heard those examples. With the 2020 Act, we had the growing and exploding online transactions, some sort of framework being given with the consumer protection e-commerce rules. May not be the most perfect. They are there. Now, recently, they have strengthened these guidelines with the guidelines for prevention of dark patterns. So that is again something which is very, very current today, which is there. Then if we look at promotions, which is amongst, I would say, between product defect and promotions, probably promotions is the area which is more sensitive, if you ask me. Guidelines are there now for prevention of misleading advertisements, and now endorsements also for misleading advertisements have been brought within the scope. And earlier, this was something which was only regulated, self-regulated by the industry by a body called ASCII. Now this has got statutory force. So again, in terms of development, latest we have seen now they have come up with draft guidelines for the coaching centers, coaching facilities, institutes, and that will also come in. Then there is also the consumer personal data, which is now hopefully once the Data Protection Act comes in, it will strengthen this area, because that's again another important area, consumer data and preserving their personal data especially. And in addition to, because see, the legal remedies going to a court is a painful exercise for any consumer. So I think the effort has to be to try and address it before that. And in that direction now, there is also this National Consumer Helpline, which is there, which is an integrated approach. And you do see companies getting notices on the basis of complaints towards a resolution. So this is a sort of, just to demonstrate that the law, it's not that it is static, it is developing. Maybe at times not at the pace we would like. And India, you know, is amongst those very few countries which has an MRP regime. And I mean, this is amazing. And there are other countries which have copied us. But that is a very unique feature that, you know, like amongst the best protections that is provided, that you buy the product from Kashmir to Kanyakumari, the product price is same inclusive of taxes. And now they have also made the requirement that per unit of that product, what is the rate? So if you go to Amazon or any of these, this thing, you will see per 100 grams, what is the rate? You can immediately compare what is the, I mean, even within the same product, different pack sizes may give you different pricing or vis-a-vis the competition. So from my perspective, in the overall, I would say from a legal and regulatory framework, it's a pretty decent status. I think it is more towards implementation that the focus has to be. More laws, more regulations are not going to resolve. It's only going to make that much more compliance complex for the corporates who want to comply. Those who are on the other side, So the effect, I mean, there are, in our view, there is a pretty good plethora of regulations are there. Issue is of implementation. And yes, I did hear that this act is much more bulky. Just to flip it on the other side, yes, it's not so friendly for the consumer, but also it's avoiding ambiguity. A detailed guideline means ambiguity is reduced. So, you don't have interpretations for everything. So guidelines for advertising, what is possible, what is not possible. You have detailed guidelines coming in. So the flip side, I would say one has to take a choice whether you want a thin consumer legislation, which is not having those details, or you have detailed guidelines which help avoid ambiguity and put the onus on the people on exactly what they are supposed to do. So if I may generalize, there are only actually specific sectors where the problem is there, and we heard about it also, whether it is real estate, maybe in the medical area. There are 2-3 such areas where there is a challenge in terms of the level of compliance with consumer law. And I think this is where the focus has to be addressed to try and get better there. And as regards the other sectors in the industry, I would say largely everyone wants to comply. As I said, no one wants to do that. You don't build a reputation or a brand by running rough on the consumers. No one consumer is going to trust you, because they have choices. Today, the best thing India has, you have open competition. For everything there is competition. You make a mistake, there are 3 people to take your place. And so, yes, as in any area, there will be a few players who don't play by the rule book. The black sheep will always be there. But for that, I don't think the entire industry needs to be painted in the same brush in terms of the efforts that go towards consumer protection. So with this sort of background, I had some thoughts from an industry perspective, what more can be done to promote consumer promotion. The first, I think everyone has been saying about promoting awareness. And I would add the word commitment to consumer protection for the industry. Now, how can this be done? Just a thought, Dr. Sridhar, more picking from RCS, like you have a certificate or some sort of a qualification in consumer law. Like the independent directors today, they need to pass an exam to be an independent director. Similarly, you have a professional of a requisite seniority who is a part of the corporate who has this certificate in consumer law. He or she or they, I mean, depending on the size of the business, are the ones who advise and ensure that whatever the actions of the corporate, they are in line with the consumer protection. And this can be obviously above a certain threshold, because smaller entities may not be able to afford something like that. For smaller entities, you could have this service coming from an external service provider, a professional, again, who is qualified in this sort of consumer protection law. So, I mean, this is the thought I thought that, and this can also be an added hat of a consumer grievance officer, could also be such a personality, but someone who understands consumer law and how the activities of the corporate should be to protect the consumers. The second thought I had was about external certification. For example, you have quality management systems. These are certified. Like for a food company, this is a mandate. So you have an external accredited agency which is validating your quality management system. What does a quality management system do? It ensures that the product that you are manufacturing are as per the required quality. There are other standards also, like you have the ISI standard, which we spoke about. So these are all areas which, in my view, should be extended where, as I said, if there are sectors where these issues are seen, maybe there is a need to make these sort of mandate that you shall have your quality systems audited And if there are gaps, you catch up there. The next one, I would say, especially if we are talking about FMCG sort of products, maybe literally every product except maybe for very big items, the role of the retailers. Now the retailers, especially the smaller ones, I'm not talking about all the big retailers who are very well functioning. Now I think there needs to be a better sensitivity to consumer complaints that is built in. If you look at most of the cases that go to court, or if I may say, even from my experience, where the consumer is dissatisfied, because normally a genuine consumer, I use this word, sorry, not for anything else, he or she will be happy going to the retailer, this product, there is this problem, please exchange it for me. All the times, literally, the retailer says, get lost. What is a sort of sensitivity that can be built so that there is a sort of a between the retailer and whoever is the supplier. There is this understanding that if there is a complaint, at least pick up the phone, speak, so that if this is something that can be resolved, we look at it instead of just push back every time. Because the retailer, the challenge also, I tell you, they are more bothered about their business. This is a distraction. Because if he has to pick up the phone and speak to someone, it's half an hour of his business time gone. But worth looking at if that is something which can help in this cause. And an area, joint effort of both the manufacturer or importer and retailer, I would say, for products requiring specific storage conditions. Let's say especially you have milk, curd, all this thing, or you have ice cream, these sort of things. These all require certain storage, even chocolates for that matter. Now, companies like we have taken the call, like if we are supplying in an outlet, let's say chilled dairy, we will also provide the cooler for that. So that the retailer has the necessary wherewithal to keep the cool chain. So areas where quality gets affected because of issues in the retail, there has to be a joint approach to finding a solution that the consumer receives these products in the condition they should be. Consumer helpline is another area where I think companies can gear up. For example, at Nestle, we have 24/7 and you will get a response, I mean, in third call or something like that. So something, I mean, and there are also instances where I am suggesting all our executives are busy, please hold on the line, and then they will go on with some advertisement, you know, which is actually going against. I mean, as a consumer, you do get irritated that I have held the phone for 15 minutes still hearing the same music. And after that, it will get disconnected. Again, you have to make an appropriate staffing of the people in the helpline basis your volume of traffic. And also accessibility. I mean, gone are the days where you can say Sunday we are off or Saturday we are off. Consumer doesn't look, maybe Saturday, Sunday, maybe more the consumption occasions. What do you know? You don't know about that. This was a thought I just penned. I don't know how far it will help. Like, if there is a legally backed facility that the manufacturer or the seller can make a settlement proposal without accepting the deficiency or defect. Because many times you have to fight because you say my product is not a problem. Why should I pay you anything? Or why should I exchange it for you? Because of that. So if there is something like that, I don't know whether that will help. Obviously, for high value items, it's not going to, no one is going to give you a car new because you are going to give something. But for low value items, it's probably something one could look at. There has been talk of spurious and counterfeit products. This is a big problem, I must say. As a corporate, you lose because, you know, like I was talking about our problems also. Like with e-commerce, you have at times spurious, we have had issues of counterfeit products being sold. We have had issues of illegal products. They are imported, not labeled properly, not checked for compliances with the India regulation put. And then, I mean, even with our might, we found it difficult to bring these e-tailers to take action. So, I mean, I think this is an area where a 360 approach is required. It's not only consumer law, you have the IP law, but the corporate manufacturer needs to act. He cannot just, can't leave it for the consumer to take action on his own. The consumer is too small a person at best. What? It's an unfair trade practice. Doesn't cover more than that. I think one of the things one should leverage is the mobile penetration. Now, 71%, around 71% is the mobile penetration. So why can't we use technology like QR codes on packs are already there to give more information, maybe in different languages, because you see the label is as much, you can't put, but without the balance being not overload the consumer with information that they don't understand. At the same time, probably giving it in different languages or in a manner which is more easily appreciated. That I think there was a talk about video on opening. The example was given of a gold bar, but I think it's a very good idea for high value items as a SOP that if a high value items, if it is through delivery, a video must be made. That in a way acts as a check to ensure that the consumer is not fooled. Again, a thought, I mean, I don't have an answer, just this thing. If we spoke about medical negligence, or there's this issue of Apple repair and all that, all these, the consumer doesn't have any forum. Whom does he go and consult that? It's an expert area. How do I know whether there was a medical negligence? I have to go through the whole rigmarole of a trial, call witnesses and evidence, and then try to get, and I may not have that wherewithal. And similarly, mobile or software, everything, these are all very specialized area for any consumer to have that detailed knowledge is not possible. So what sort of support can we think that the consumer can look to when dealing with such expert areas, complex areas? Thank you very much.
Thank you, sir. The idea of no defect liability is a very dangerous proposition that you put forward, but I think it's worth exploring. Now I hand over to, I think no introductions are needed, Professor Keshav Rao, sir, currently adjunct professor, Nalsar University, former Vice Chancellor, Nusral Ranchi and DSNLU Visakhapatnam. Thank you, sir.
Professor Rajendra Prasad, Professor Anita Rao, Sri Santosh Ji, Sri Murali Balasubramaniam Ji, and dear colleagues, a very good afternoon. If anyone is to be punished, give him a session after lunch. Well, I'm very happy I'm the second one to be punished because he has taken the lead role in facing the impact of talking after lunch. Friends, whenever we speak of Consumer Protection Act, we always talk of only two things: defect in goods, deficiency in service. And most of the activists, advocates, do not know that there is a third D, which is part of the Consumer Protection Act. The first D is defect, second D is deficiency, and third D is deception. Deception in promotion of goods and services. And it's given a very attractive name. It is called UTP, Unfair Trade Practice. I'm going to deal with the unfair trade practice only. Let me start with two very bold statements. Number one, there is no duty to speak the truth the manufacturer of a product need not tell the truth to the consumer or to the dealer or to the retailer or to the distributor or to anybody for that matter. But saving clause is there is no right to tell a lie. So these two opposite statements, the thesis and antithesis has to be synchronized, and the synthesis is what is adopted by the manufacturer who wants to promote his product. And the synthesis is half lie. Half lie, not half truth, half lie. It is not a total lie, it is not truth, but it is half lie. If you use our toothpaste twice regularly in a day, I repeat, if you use our toothpaste twice regularly in a day, it will help you to fight tooth decay. Fantastic claim made by the great manufacturer of toothpaste throughout the world, Colgate. Colgate. And Colgate is the greatest toll gate for us because you have to start every day morning with that. Analyze the statement. If you use twice regularly, morning 6 a.m., evening 10 p.m. If it is 10:1, it is not used regularly. If it is 5:59, it is not used regularly. How much? In the advertisement, they will show no. On the brush, it must come like this and it must end like this. If you use like that, one entire toothpaste will be over in 5 days. And we normally prefer to have a toothpaste for not less than 15 days. Some people like me, very conscious people, even 1 month. But then he expects us to use the toothpaste in such a way that the toothpaste is consumed within a week. And even we use like that, perfectly satisfying the condition that is laid down in the beautiful claim he made, says it will help you. When you help yourself. For what? In fighting. Fighting what? Tooth decay. It never says tooth will never be decayed. Never. That is the half lie. And we read the statement, we feel very happy, and we purchase, we use it, the decay remained. Tooth remained like that. Purse got emptied. This is the only gate of the whole gate. This is the half lie, you may say. Sir, nowadays who is telling truth? I assure you, if before marriage, whatever great qualities I had, what to be told by parents, I would have never got married. My parents told the opposite party that my son is the best. And my son is going to become collector, ticket collector, not IAS collector. So, telling a lie is part of our life. Why do we find fault with the traders, the manufacturers in using it when we are not hesitant to use it? Leave that. So, friends, unfair trade practice is a beautiful practice which is there in the MRTP, included in the MRTP. When the MRTP was released, they found no other statute. They thought it better, let us put it in the Consumer Protection Act and forget about it. And it was totally forgotten. Consumer Protection Act, the definition of unfair trade practice is a descriptive definition, not a prescriptive definition. It's very, 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 very lengthy. And it was made more lengthier after the 2019 Act came into force. And very lengthy definition is given, very descriptive definition is given, but I am going to refer to only 3 practices. Number 1, McDowell soda is advertised. Who takes McDowell soda? Virat Kohli. Reserve, what is it? Royal Challenge. Royal Challenge is suggested by that Hindi actor, what is that name? Salman Khan. Some Amir Khan. Some Khan. And what is it that is actually sold? What is it that's actually marketed? McDowell whiskey number 1 or McDowell premium whiskey, Royal Challenge beer, Royal Challenge whiskey. We all know what he's telling, but we are carried away. McDowell soda, Royal Challenge glasses. Well, can't he find any other brand name? What the manufacturer is doing is he is marketing the product which is not expected to be advertised, which is whose advertisement is prohibited. When alcohol advertisement is prohibited, we are using this beautiful surrogate method and we are trying to present it. Can't we say that a brand name can be used for only one product? Or maybe I'm very harsh, let me change it. Can't we say that a brand name cannot be used for a product whose advertising is prohibited? I think this is one area which needs to be undoubtedly considered. I request you to kindly reflect over that. The second one. Pardon me, I'm going to tell my own experience. I saw an ad. On the first day, the face is like this color. Second day, third day, fourth day, fifth day, sixth day, seventh day, face color became like this. Fair ever cream. Fair ever. Fail ever. And of late there is a new innovation. Fair ever men. So cream separate for female, cream separate for male, and probably the next is cream separate for old ladies because it eradicates the wrinkles. My wife is waiting for that. I can't help. If it comes, she will purchase without my permission. So friends, honestly, I'm telling you, let me make a confession. I have purchased that Fair Ever Men cream. Used it strictly as prescribed. And unfortunately, not even iota of the color of my face changed. Huh? Glowing because I am staying mostly in the AC hall, not because of the cream. And okay, I am only fooled. Fantastic. No problem. When you trust somebody, only that fellow can fool you. A person whom you don't trust can never be fooled. I trusted the product, I got fooled. But then there is a wonderful advertisement which I saw, which I think is being shown now also. One product. And I go. 20 ladies are running behind me. It is shown in the TV. I also tried once. And I confess I utterly failed. Not even my wife came after me. Is it not? I don't know what is the word to use. Spoiling the image of the females of this country? Is it not belittling the image of the females of this country? How should we allow such advertisements to be released in public? I call them obnoxious ads. The first one, which I referred is surrogate ad. The second one, obnoxious ad. And the third one. Only these 3 points I wish to place before you. Third one. Beautiful advertisement, last page advertisement in a newspaper. Hero Honda, Kawasaki, bike, 60 kilometers per liter. Oh my God, 60 kilometers per liter. I purchased and I tried. I'm a good driver. And I found that it doesn't give more than 22 kilometers. Very 60 and very 16. And I saw the paper again in the bottom, at the bottom, in small print, which I can't read unless I use my specs. It is written under test conditions. What are those test conditions I wanted to see? At no point of time on the bike, there must be more than 40 kgs. If it is 39.99 or 40.01, it is not a test condition. And on the road on which the bike has to be driven, there should not be even 1 inch, what you call, up and down. No? Sir is telling me, I am thankful to him. Now, is there any such road in India? I don't find. Of course, you are coming from Andhra Pradesh where the roads have not been touched for the past 5 years. Therefore, your experience is different from our experience. In Hyderabad also I drove. Both are same. So friends, test condition. It's small print. And of late, mutual funds. They advertise in newspaper when you are seeing some serial that somebody comes and says it is better to invest in this mutual funds. And past it, you are advised to read the document and the conditions carefully. And what is said so fast that you can't even understand what he is telling. So you are carried away by the 50%, the mutual funds. So you purchase, fantastic, small print, ads. These are the three. And yes, oh yes, save our souls. We have to save ourselves from these three different kinds of ads. How to save? Only by bringing it under UTP. And UTP, there are 10 clauses. If at all there is a possibility to bring it by even stretching the language and giving the most liberal meaning to the word that is used in the statute, that is section 2, clause 47 of the Consumer Protection Act, you will find you have to bring it only under clause 1. Subclause 1 of section 47. And subclause 1, I read, it is only about the product quality, quantity, grade, composition, etc. But it doesn't speak about the small print or the surrogate or the obnoxious ads that are there. The language that is used, you can't bring it under the framework of section 47, clause 47 of section 2. So UTP, which is having a very lengthy definition in the statute, doesn't serve the purpose at all. In fact, it is giving a green signal to the manufacturer and to the advertiser and to the publisher and to the endorser, in case it is endorsed, to go scot-free. No law governing them at all. And sir rightly pointed out, in the Consumer Protection Act of 2019, there is a provision for endorsement. See the cleverness? They defined endorsement without reference to a person. The endorsement definition only speaks about the process. It doesn't speak about the person. And the person is the endorser. It never defines who is an endorser. That means the clear intention is the endorser should not be made liable. Can never be made liable under the Consumer Protection Act. So from endorsement we are not protected. From Consumer Protection Act, the definition of UTP, we are not protected. Then I am the consumer. Well, for my trust in these kind of advertisements, I got deceived. Deception was practiced, undoubtedly. What is the remedy I have? I have no remedy except that which is available under the Consumer Protection Act. And I made a survey of the remedies available under the small letter, small print. Second is obnoxious. Third one is small print. Small print ads. Have you given any other name? No, I have not given. This is SOS. No, S is surrogate. O is obnoxious. S is small print. SOS. You can remember SOS, no sir. Very difficult to remember the three names, but if you remember the SOS, three will automatically come. Now, the consumer forum has the power to direct discontinuance, or to modify, or to impose penalty, or to prohibit endorser but who is an endorser not defined, or to ask for a corrective ad to be issued. And the practice of issuing a corrective ad is to point out what all has been said in the previous ad. It amounts to reinforcement of the ad, but not the correction of the ad. And then cease and desist. These are the provisions available. Now, unfortunately, these will not help us at all because there is no screening of the advertisements to be done. Censorship is not there. Censorship by publisher is not there. Censorship by the advertiser is not there. Censorship by the manufacturer is not there. Nowhere there is any possibility of any censorship. I think this is the third important factor that requires an independent authority to screen even before it is released to the public and then say whether it is worthy of releasing to the public or not. But these three considerations I place before the honorable members to kind of reflect on them.
Only the official body is doing the tax.
Correct. Advertising Standards Council of India. And to get information from them, I went to Mumbai 5 times when I was doing my PhD on advertising. 5 times. They refused to allow me inside. Sir, somehow Indian thinking is totally secret. I don't know what is the sinister motive this fellow has. He's coming to us. This is the approach. But nowadays, thanks to the ASA, the judgments are available online. So we can see. But is it sufficient? There is a Doordarshan code. There is All India Radio code. There is a Press Council code. And there is a SEBI code. So all these codes are there, but many people do not know that there is a code. But even if code is there are ways to circumvent them. Like they came out with using the same brand name to advertise those products whose promotion is totally prohibited. So we know how to circumvent. Now how to stop that circumvention is what we have to think. I am placing before you, rather I have placed before you these three. Can you ever imagine Amitabh Bachchan sitting on a bike and he's telling very comfortable journey. If he can't even sit because he lengthy legs, but he says a comfortable ride I have. And on the one side it is Sunil Gavaskar, on the other side it is Virendra Sehwag. Both of them are having something. What is it? Some pasand. I don't know what is that pasand. इनमें क्या पसंद है मुझे नहीं मालूम क्योंकि हम अभी अब तक इसको टेस्ट नहीं किया मगर it is being advertised and latest advertisement, a beautiful advertisement, very thoughtful, innovative, creative. Mahendra Singh Dhoni is holding the ball in the hand and there is Deepak Chahar, both are playing for the same team. He says, take the ball from me. Deepak Chahar is unable to take the ball from hands. See how strong it is. Even Apollo tire is equally strong. Thank you very much.
We are living in times when a joke is considered offensive. A joke, we get offended by joke, but we always forget that satire is one of the most beautiful tools to drive home a point. And I think Keshav sir beautifully used satire from his own experiences to drive home the points that he wanted to. Thank you, sir. Misleading advertisement. Thank you so much, sir. Now we'll open the floor. Yes, yes. He has unpacked what we call as the asterisks. In every advertisement, we'll have an asterisk which says conditions apply. He was pointing out that the conditions apply has to be bigger. You make it so small, that is what he referred to as small print. the small asterisk at one corner, and at the bottom we come up with conditions apply. Thank you so much, sir. Now we'll open the floor for any Q&As for 5 minutes to the esteemed panel. And I would like to open it first with Santosh Kakde, sir. My own question, sir. What about liabilities with regards to over-the-counter selling of drugs? How do we fix liability? Yes, sir. Please.
Drug exhausted can't find quantity. Does it mean say environmental proper prescription or just any consumer can go and drugs are can be sold without any some drugs can be sold
The point is, when we purchase a drug, there will always be a slip attached to it, which says these are the conditions that you have to follow. Like you point out, the conditions apply, the small print. When you sell it over the counter without a prescription, maybe it comes with a slip. There are two conditions, one with comes with a slip and one with doesn't come with a slip. In that case, who is liable? Is it the seller or is it the manufacturer? Some products are being sold over the counter without prescription. Thank you, sir. Anybody else? Any questions?
subject of health is the states of that's
That's such conditions. And I really like
just a matter of 1 hour journey from Chennai to Delhi.
it is not.
Some drugs.
Yes.
I cannot find it. Check from the. I am doing the service.
Murli sir, one question. You pointed out about redressal at the grassroots level. at retailer level if we could address an issue. In the industry, was there ever a thought process of a mechanism of incentivizing such redressal at the retail?
In a different place, for example, we have bad goods, for example, or product expired. So we take that. Thing is left with the, we will take it back. So these are measures where we provide something wrong in the first instance. Whereas if there are companies who say we give you a commission for bad goods, now it's up to the retailer whether they destroy it or they sell it.
No, sir. I was specifically referring to one aspect that you pointed out is the pushback coming from the retailer. To avoid the pushback, you also said that we could use a mechanism where we could try to redress the issues at the retailer level itself.
That's what I said. See, the challenge here is that it's not willing to spend their time to do this. They see it as loss of business.
Exactly, sir. So can you actually incentivize redressal at the retailer level? Have you ever thought about it in the industry level?
See, yes, in all this, you have to see the check and balance. Because you can do that and then you'll only have claims coming your way. Because that's the way it works. So the check and balance.
This is an industry pushback to the retailer.
Yeah, you have to have the check and balance.
Yes. Okay. Fine. Anybody else? Any other questions? Fine. Thank you, esteemed panel. Thank you. Yes, sir, please. No, I told it is a very dangerous proposition that he is bringing in. Yes, sir. Strict liability, yes. Yes, sir. Yes. I was referring to an industry expert talking about a no defect liability being a dangerous proposition.
Because see, the strict liability is one thing, but what I think we both are saying is slightly different. Is that see, that can be there are many cases where you cannot establish where is the problem. Frankly, because it could very well be that the consumer has used the product wrong. I mean, we were talking about that exception. But you as a corporate may want to settle it because it saves 50 rupees. You don't want to spend 50,000 rupees. But then what comes in your way is that if I accept this liability, am I going to? That's what?
Yes. Yes. Thank you, esteemed panel. Thank you for your time. Okay. Wait, let's come. Yes. Now we begin session 2. The theme of the session is redressal mechanism. Now I invite upon Professor V. Hemalata Devi, Professor of Law, ICFI Law School, Hyderabad, onto the dais, who would be the chair of the session. Now I invite upon Dr. T. Vijay Chandra, Professor of Law, retired Kakatiya University. However you're comfortable, sir. Thank you. Now I invite upon Dr. PVVS Murthy, sir, industry expert, to the panel. అందివ్వడానికి ఎవరు లేరు. ఇచ్చేయండి సార్, ఇచ్చేయండి సార్. మల్లికార్జున్ సార్. Okay. Now I call upon the chair professor, Professor Sharma sir, to felicitate Professor V. Hemalata Devi. Now I ask Professor Sharma sir to felicitate Dr. T. Vijay Chandra. Now I ask Professor Sharma sir to felicitate Dr. PVVS Murthy sir. Leaders. I would like to hand over the mic to our chair, Professor V. Hemalata Devi.
Hello. So our co-chair, due to some preoccupied works, he could not be here, Professor Balakrishna Reddy Garu. And the speakers, Professor Vijay Chandra and Murthy Garu, who is a consumer activist. Professor Sharma ji, who is the coordinator of and who is instrumental for the organization of this particular workshop. Professor Rajendra Prasad, Professor Anita Rao, and all other renowned guests who are here. Professor Veena, who happened to my own colleague, and other participants. And here, Professor Sasikala Gurupurji also is here. She is the director of the Symbiosis Law School. Professor Keshavrao ji and Professor Venkatrao, who left on some important work, and other colleagues who are present here. Good afternoon, everybody. Yes, this is really a post-lunch session. Of course, we will try to do justice as far as possible. And then at the outset, let me thank Professor K.V.S. Sharma ji, who is the chair professor of this consumer chair from the Ministry of Consumer Affairs, and Professor Sri Krishna Deva Rao, who is the vice chancellor of this great Nalsar University, for giving me this opportunity to be here in this session, to chair the session. And this particular session is on redressal mechanism. Of course, unless there is a dispute, redressal question won't arise. So here, because since morning, right from the inaugural session, with the presence of Honorable Justice Jaiswal ji and Venkatrao ji and other guests in the inaugural session. So till the recent session, so chaired by Anita Rao and Rajendra Prasad, we have been hearing two very, very important concepts. And this morning also we heard very nice things about this consumer protection, various dimensions. So now, because before only confining to the redressal mechanism, because all other things are very well discussed in all these inaugural and also the followed sessions. So now, before that, at least as a backdrop, and we all know that the consumer, because I studied one quotation, but I don't remember the author of that quotation. See, the consumer is a very honorable guest in our house. So he has, because unless the consumer, there is no business, there is no manufacturer, there is no seller, nothing. So consumer is a god. So you have to respect the consumer and we have to protect the rights of the consumer. See, if it is going naturally, there is no need of the legislations. So we had the Consumer Protection Act 1986 and the Consumer Protection Act 2019. So because it is very clear that 19 is not an amendment. It is completely replaced with 1986 Consumer Protection Act. It's a new act because the legislature actually, instead of amending here and there the old legislation, the legislature took very much care that to make it as a separate enactment by replacing the old act. So of course, it is a fact also because there are quite a good number of changes. If it is one or two change, either in the form of new addition, incorporation, or in the form of addition, or in the form of deletion. So there are quite a good number of changes from the old act to the new act. So that is the reason why instead of just amending here and there, making it so clumsy, so better to go for a new act where there are 107 sections in the new act, whereas only 31 sections are there in the old act. And also, of course, we have 8 parts in the new act, whereas only 4 parts in the old act. So because, the parts and sections also matter. Because, unless you have the extension, so you cannot incorporate the very important, what you can say, the aspects of the consumer protection. So, and prima facie or the foremost, the Consumer Protection Act had come as a revolutionary response to the KV temptor, because we all know that. So earlier, the buyer beware, that was there in existence before 1986. But it is very, what you can say, evident that, see, the buyer cannot take care of all the aspects of a commodity or a service, because this is mainly meant for the, what you can say, the goods and services. And of course, you can go for the redressal whenever there is a defect in goods and deficiency in services. And of course, the third D also was pronounced by Professor Keshav Ji. That is the, yes, deception. So here, that is, mainly the concept of consumer protection revolves around these aspects. So for that purpose, actually, because, of late, so till 86, so nobody could recognize to what extent the buyer can take care of the goods in the open market. See, after all, you can go only by the color, you can go only by the size, and even in the measurements also there is a deception. Because even the measures, weights and measures also, though there is a separate act, because we are easily be cheated by any person, either in the service or in the goods. So till 1986, nobody thought of, see, this consumer, what you can say, point of view. So only thing is, because the things are available in the open market, okay, you can choose one, because this is your voluntary non-fit injuria. See, if something goes wrong, so you yourself have selected. Okay, we know only whatever that are there apparent on the face of the goods, but we cannot assess or estimate or detect. See, whatever is there, what type of ingredients that are used in that, and how, suppose, especially the textiles, because there may be some allergenic, what you can say, the ingredients that are used in the fabrics. So like that, there are many, even if it is prima facie on the bottle or on the good, everything is written, including the allergic or non-allergic or something, that if it is a vegetarian, the green symbol, and if it is non-vegetarian, a red symbol. But I don't know, because all these things, and to what extent they are really mentioning, and even if they mention also, how many, what you can say, the consumers can read and go through. See, after all, we are not able to, some of us are not able to find out the expiry date. So that means it is evident that the expired goods, banned goods, especially in the healthcare industry, so they are being used, they are being sold in the market and the medical shops, those who are banned in the other countries, as if the life of the Indian citizens is not a life. Because, you have right to life under Article 21 of the Indian Constitution. So the medicine banned in X country, so is it not a common sense point that it is also does some harm to the health or life of the individuals in India? I don't know how they could get the permissions and to sell certain banned medicines. Of course, expiry. Suppose, they can even remove that with great respect to the great, what you can say, that is healthcare or the medicine. and great respect to the doctors and the medical service providers. So here, they can even take out the slip and then they can paste another slip with another date, expiry. See, even the consumer, that's why, it is a joint liability because, the previous speakers also speaking. Suppose, if you also, and just before forgetting, let me make one, what you can say this thing, the over-counter medicines. Because I think somebody asked the over-counter medicine. See, over-counter medicine means without any prescription. See, we are going to the medical shop and we are thinking that the compounder is a medical expert. See, I have this pain. So please give me one tablet. Because unfortunately, there is no regulation, there is no law banning the over-counter medicines in our country. Then he will give. If he says that, sir, is that prescription with you? No problem. I have used it previously also when I got a headache. So what he presumes is, okay, as long as we have head, we will get the ache. No, that is not a big problem. Okay, and then he gives some tablet. So unfortunately, if it is cured, no problem. Or if any, because don't think that headache is only for one reason. Maybe many reasons. So without going to a doctor, without getting diagnosed, without prescription, we are going and asking the medicine. Why should we blame the medical shop fellows? So that is why I'm telling this one is because many things that are banned in the developed countries, especially, we are continuing still in our own country. So whatever may be the reason. So that's the reason why, how can we strictly, what you can say, implement or rely on any legislation that is available in India when it comes to the implementation part. So this is one thing. And many aspects, because I'm not going too deep into the details of other aspects because they are already discussed in the previous sessions. So here, see, there are many additions or whatever is not there in the previous, that is the old act. There are many additions like introduction of the mediation especially, and also the change in the definition of the consumer, change in the definition of the, what you can say, the goods. Because, now with the advent of the electronic, what you can say, the markets or the e-commerce, the development of digital, because now our life itself is e-life. So completely we are depending on the technology. So with this advent, of course, there are many developmental changes that have been incorporated in the 2019 Act. So there are, of course, those many things like, for example, see now the consumer definition also expanded that the electronic consumers, that is e-commerce consumers, they are also added, etc., etc. And then of course we have these, what I can say, the unfair contract, unfair trade practices, and Professor Keshara Garu had very elaborately discussed about it, no need to discuss again. And then, the pecuniary jurisdiction also, there is change from the old act comparatively. So there are other things like, alternate dispute resolution mechanism, and also the filing, because alternate dispute resolution, earlier it was not there. Under that, the mediation only, it had been incorporated in the new act. But how this mediation also, because this morning, Justice Jaiswalji, he was very clearly, mentioning about the practical aspects. Really, it was, there are certain drawbacks, even with this new act also, that I will also discuss. And also there is, what I can say, the provision for the penalties for the misleading advertisements and endorsement of the goods and all, so which were discussed by. So now these are all, of course, the generally, what are the, we can call them as the developments, we can call them as new inclusions, because, the main aim of the legislature when making this 19 Act as a separate legislation, instead of amending the old one, so that is, to do the complete justice, or what we can say, in order to protect to the maximum extent and effectively the rights of the consumer, and also to provide security to the consumer, especially in this, what I can say, the digital era, and also the e-commerce world. So that is the reason why the legislature has taken a special care. Otherwise, it would have been easily amended because, there are not many, what I can say, the concrete this thing. So then, coming to this, what I can say, I'm only confining to the redressal mechanism because that is the sub-theme of my session. And also I have to provide time to the other speakers also. So now here, as far as this is right from the complainant, because, there is one change in the definition of a complainant, that this also includes the minor. where the parent or guardian also can file a complaint if at all any deficiency in services or defect in goods. So that is one addition which was not there in the definition of this one. And the definition of services, actually here, what I can say, this morning also this discussion had come. So the services here in the old act or in the new act 2019, so there are certain inclusions, but especially if I am right. So especially it is 2019 also did not specifically or explicitly included the medical services because not explicitly. So because when there is other services, certain I think engineering services or something had been included. Am I right? And then other services that means you are diluting. See here the medical negligence, especially in the Consumer Protection Act and the redressal mechanism, see the very prominent role is played by only the medical negligence. So of course that also is to be proved. There should be a sheer negligence. You should have taken reasonable care. That all there we have studied, and also there are many cases on this. And also see here in this case actually, if you explicitly include, because these medical services, so some emphasis I think would have been laid on the medical services and also education. That is one. See, because there were doubts. See, unless there is an explicit inclusion, definitely that leads to some doubts or suspicion. See, there one case actually, I mean, I think if I am right in our own university, for the revaluation. Because they are taking a lot of time for the revaluation till the result come. And if at all there is any increase in the marks, so the student cannot go for either for the higher education or whatever it may be. That is all his livelihood or life under Article 21. So there was enormous delay. Then that student had filed in the Consumer Protection District, then forum, now commission. So because I know you all know, 1919 Act, 2019 Act changes the nomenclature of the district forum into the district commission, because all the three, let it be uniformity. Why district only forum? Other two state and national or commissions. So that is the reason why here, they have filed in district forum at that time. No, but there was of course a benefit of doubt. See whether this can be included under the Consumer Protection Act or not. So that is the reason why, in some cases justice may be done, in some cases may not. That all depends upon how the arguments, go on. So if there is an explicit inclusion on the very important services, so then, there is no, what I can say, the benefit of doubt. So this is only, of course, my personal feeling. I don't know whether it is feasible or not, if at all any amendment is to be made to the 19 Act. And then definitely we can make it as a one point to be noted. If the legislature takes it or not, that is a different matter. So that is as far as the, what you can say, this thing is concerned, services is concerned. And also, okay, say as far as an advantageous part, it allows the e-filing also. Because now the e-commerce, we are taking into the digital era. So earlier act, only the filing is in the place of the seller's business. But in this 19 Act, not only the seller's business, but also the buyer, the place of the buyer where he lives or works. And in addition to that, of course, because this electronic, what you can say, the transactions and contracts, business and everything now, electronic, these things are recognized. So file from any place, that is, that is not a territorial jurisdiction because it is online. So the thing is, actually this morning, Jaiswal ji also is discussing about this, which is very important thing. Whatever may be the mode of filing, but the thing is here, see what about the petty or small or common consumers? Because everybody, this is not a new point, not my invention or innovation. So many people may be thinking about it. And also Justice Jaiswal ji also had made it very clear. So now the question is, and if you observe the pecuniary jurisdictions, because I have discussed with my colleague Dr. Veena also while preparing for this workshop. See, what about the common man? Because the moment he sees the pecuniary jurisdiction, oh my God, see, this is only, the value is only 10,000. See, how can I go to the district, what I can say, the commission, or forget about state and national commissions? So in such cases, actually, I also feel, and fully, very happy that Justice Jaiswalji mentioned, at least at mandal level, if not, I mean, he also proposed at the village level, well and good, but if not possible, at least at the mandal level, because we know the effectiveness of administration of justice, it is based on the access that you are providing to the justice, very important. Unless you provide access, how can you expect the administration of justice? So access to be provided. See, the small consumers, unless there is an access, by any means, by pecuniary value or by the proximity, so then only, we can encourage the consumers to go for any of these, what you can say, reasons that what they can file, then automatically the consumer movement, what you say, or the consumer justice, or, because still 86 first act, 19 new act, but now we are in 24, still we are thinking that awareness should be created. So when we are going to create awareness, because we have so many activists. For example, Mutikar is there very Ratna with us. So there are so many programs going on. Chairs are established in many of the reputed institutions. So, but still, so because, there may be many reasons for this. So that is also one area which we have to keep in mind. And of course, with a plus point now, this what a hearing of the parties, or these things can be conducted by the video conferencing and all, which was not there earlier. And another important thing is what I can say the thing. So of course, mediation also we know. So mediation, that is also again the quote next mediation. And there also what I can say, not all matters can be referred to the mediation, because we know that mediation rules 2020, consumer protection mediation rules, they list out what are to be referred to or what are not to be referred to. So now here, another important thing is, what you can say, the driverless, the compliance. Because I think you have all studied this Consumer Protection Act 2019. See, in the 86 Act, does it know what I can say, the fault cases? See, these driverless compliance, so now there is no mention regarding, because they, in the old Act, they were being dismissed. See, either for the dismissal or for what I can say, the penalty, whatever, but totally that provision is absent in this, what I can say, new Act. So before that, I got one point regarding the medical, sorry, I'm going back. So here, that the health services inclusion, it was there in the draft stage. Because 2019, when it was in the bill shape, actually they have included the health services explicitly under the definition of the services. We don't know what happened. They have taken it out in the final act. So that's what happened. Okay, here, because, suppose if you don't what I can say, dismiss or give some penalty, impose some penalty for these frivolous or what I can say, these faulty these things. So then, the people will, because, nothing happened, let us try. Because we always, okay, let us see to what extent the Consumer Protection Commission will work. Is really going to do something for us? Okay, I will try. See, whether it is genuine case or not, when there is no provision in the law, so then the people will definitely take it, for granted. So that's, and what is, okay, you may think that, okay, what's the problem? There is no provision. Okay, what is the problem? Yes, there is a problem. See, because, if you just go on a trial and error, so many people without proper base, especially in the medical services. So, just like that, they will go to the either, depending upon this, what you can say, the value, depending upon the pecuniary jurisdiction, they may go to the district commission or state commission or national commission. And then ultimately, okay, it may be proved that no, it is not a genuine complaint. So what? See, what happens, because if you remember, and even now, see the medical legal cases, see the doctors and other health service providers, they are very much afraid. Are Baba, why getting unnecessary headache? No, we can't do it. No, now of course, you cannot reject. That is a different matter. So, because, they are afraid of. Suppose if you say that, everybody, you are all being brought under this Consumer Protection Act, and there are so many cases that are filed. So even these, okay, it is a, what you can say, not a genuine case, ultimately it may be proved. Okay, if the doctor is proved that not guilty, Are you going to give any compensation to him? Because he had undergone so much of loss, because when the moment the complaint filed, then the patient stop coming to him. So one way we are depriving him from his profession, earnings, which is directly hit the Article 21 of the Indian Constitution. And then another thing is, see, till then, what is the mental agony? Because nowadays, the doctors are very much aware about the medical legal aspects. So, what are you going to get it back? So there is no point of the compensation on anything. So for the if he is not guilty. So because of these are all the things which are being taken into consideration. If you allow these the faulty or the false compliance, especially in this consumer area, this is actually the very, very important point. And then of course I don't know how much time I have taken, but here, because all the other things which are there, technicalities, what are that are included in the this act, new act, and then this especially the mediation, of course, what I can say, it's a very welcoming inclusion, because this reduces the cases, the load of the cases in the three types of commissions, the three-tier commission. So that way it is welcome, but again, of course, to what extent as our Jaiswal ji, Justice Jaiswal ji very rightly pointed out, see, it is not a fight between equals. Say, for example, if you want to go for a compromise, see, at least more or less, with a degree of differentiation, there should be equality among the parties. See, as Justice has rightly pointed out, see, we cannot go and give our head to Tata's Birlas. So, because even for that also, see, the consumer who is a victim of something, the defect or whatever it may deficiency. So, first of all, is he dare enough? See, forget about the mediation, even for raising a complaint. First of all, see, because the patience and the compromise, see, they are inbuilt. They are there in the blood of the people who are residing on the earth of India, I can say. Because for many things, we have patience and we compromise, even if we incur so much of loss and all. So in such case, whatever may be the new concept that is introduced or incorporated in the new act, or whatever may be the dynamic changes, because it's very clearly pointed that this act is not merely to change the buyer-seller dynamic, but also to protect the consumer's rights to the fullest extent. How? It is a question mark always, because we always say in every program, see, because there is no depth for legislations in India. Even there are more than required. But when it comes to the implementation, so then whom do you find fault with? Because everybody can say that, at the end, see, the legislation should be properly implemented. Who will bell the cat? It's very easy to give a suggestion, but what is the methodology? What are the modalities? What are the aspects? How can you implement? And definitely there should be some severe action for the non-implementation. See, that is a very, very, see, for example, now this was the non-compliance. So there are penalties, non-compliance of the order, there are penalties. So that like that, suppose if the party doesn't comply with, there are penalties. And suppose, if there is what I can say, that non-compliance on the part of this implementation machinery, then where is the action? Where is the penalty? And where is the compensation that is being given to the victim? So these are all, of course, it is very easy theoretically to speak, but very difficult to implement when it comes to that practical point of view. Of course, with this, once again, I'm thanking Professor Sharmaji, Professor Sri Krishnadeva Rao, and I forgot Raghavendra Rao is here who could guide me this morning, and to the National Law School as such, the Nalsar University in general, and also all these, what I can say, these moderators, and everybody had done their work in a very, very nice way. And thank you, Sharmaji, for the very nice reception and also very cordial hospitality and everything, and excellent academic sessions. And I also learned certain things because I'm not a master in the Consumer Protection Act. So once again, thank you very much.
Thank you so much, Pam. I'd like to call upon Dr. Vijay Chandra, Professor of Law at Kagatya University, as the first speaker for the session.
Chairperson, Madam, for a very model example at this age and time. And I'm audible, no? I think, is it okay? Thank you, thank you. I'm promising you I won't take much time. You can believe me, because I'm in the ninth down batsman. Okay, so I don't want to tax you, but straight away into the point. Supreme Court said that in Baba Ramdev's case, okay, you have a right to sleep is a fundamental right. Okay, thanks for not sleeping. I'm observing your mode so that you won't go into sleep mode. Okay, now thank you for not going into sleep mode. Now, friends, coming back to second point is, my subject is international space law. So I have come down to earth as a consumer. It's not my subject very fairly and frankly, but of course the industry and the consumer manufacturer relations are extending to space also. There may be space villas very soon. So it may extend, and thanks to the new Consumer Protection Act, which says that a case shall not be filed in a defendant's place. Sorry, defendant's place and not space also change. Okay, these are all the small this thing. And coming to the straight away to the point, most of the points I thought of sharing with you were already being very well projected in the morning by learned chief guest. 100% they have reflected in my mind and writings here. So I don't want to go much into them. Okay. So I will just focus on some main points. The first thing is that what I will on a lighter side, I will present the important points. The first thing is online is so comfortable and so discomfortable equally. That is the first observation. Some observations, on 5 or 6 observations. It is so comfortable because things happen at home. It is uncomfortable because we are being cheated. Now, a person has ordered something online. What is it all about? He said how to kill mosquitoes. We want to get rid of mosquitoes. So next day he got a parcel, as sir was telling in the morning. In the parcel, there were 2 stones and 1 note. The note said, catch the mosquito, put it on 1 stone and hit it with the other one. So that is the best method of killing mosquitoes. So this is the online wisest, that is all may be possible. Coming to the next important point is, as morning observed, important observation is, as all you know that the Indian laws are very complex, very sometimes often confusing which way to go. That the Honorable Chief Guest was observing. This creating a problem, and Supreme Court observed on that. What Supreme Court said was, our complexity of the laws is like, it makes lawyers laugh, legal philosophers weep. You are interpreting this word and that word. This makes the things more complex. And in the new act, what I sincerely observe is that there are a lot of, overlappings or over descriptions. That is my one observation. Now, other important points I would like to focus is, for example, the consumer is burdened under this new act, what I feel. For example, if anything is sent to the lab, who should bear the expenses of sending the material to the lab? It says the consumer. How far it is fair is what I feel. Okay, now, for example, yesterday, unfortunately, to witness this incident reported in the newspaper. A girl in Punjab died after ordering a cake, birthday cake. Very, very unfortunate. Takes on Punjab law. Now it is a legal battle for a consumer. So who should bear the expenses? And particularly the lab expenses at all. It is unfair, that is what I feel, that putting it completely on that person. It's the government duty at least to provide, or at least some slabs up to so and so level. For example, in medical negligence case, very difficult to prove for a poor victim patient, and when the question of bearing or other expenses in a burden, when the question of testing comes. I practically have my own personal case of filing a case against a doctor for medical negligence. My sister has delivered a male child, died in 48 hours of his birth. We filed a case in a consumer forum. The case went on for 6 years. We failed to prove it. Totally. They called expert doctors and the show went on. Unfortunately, we could not prove it. So in such a situation, the consumer is overburdened. Yes. Yes. Yeah. Right. Yeah. Yes, these are the things really. Right, okay. So these are the things as far as the negligence and proof are concerned. The next point I would like to highlight is the Central Consumer Protection Authority, right, which is being created. What kind of body is this? Was a judicial, administrative, corporate body. That was the thing which was lingering in my mind when I read all these provisions. The word corporate body has been used about it in the rules concerned. It says that it shall be a corporate body. What is the meaning of corporate when you look into the definition? Corporate indicates a big company. I don't know why it has been crept into this word. That is one of the doubt or where I have observed while studying the act. And the other thing is legal personality, and it was given extensive powers. The authority, I try to compare it with the National Human Rights Commission, like come to the rescue of the consumer simultaneously. But there here, the point is it can impose 10 lakhs fine. That is another thing absurd. But whereas the district commission can impose the fine up to maximum 1 lakh. 1 lakh. Ante kada? So which body is like, that's what I'm telling. There are three bodies. Either they run parallelly or interconnected under the act. So this is what I observed. So won't it create a kind of confusion? And next, as has been submitted in the morning, how the 10 lakh rupees is to be recovered, even if it is imposed by the administrative body. Is it a revenue amount to be recovered or what way? Again, the same story starts. This is one observation. Coming to fines, as you know that, interestingly, the act says only maximum fine is 1 lakh. District commission, am I correct? It is only 1 lakh rupees that can be imposed. Is it not a too small an amount? Sir?
There is no such festival.
Up to 1 lakh. District commission. Are you sure, sir? It says up to 1 lakh. Okay. Because maximum imprisonment 1 month and up to 1 month and maximum 3 years. And similarly, the fine is minimum 25,000, maximum up to 1 lakh. Right. Thank you for correcting it. Then it's no problem. Coming to mediation, one of the wonderful the system that has been evolved by it. But what I observed again is mediation is again has its own vices. When you look into the rules of the Consumer Protection Act, it says that number 1, 3 months time. Okay, now what I observed in the whole act is every time the time given to for scrutiny and procedure is 3 months. The time given for disposal is 3 months. Whereas for a notice, they are, for example, to give a notice to the other party, give a copy, 21 days time is given. What is the rationality of this period? 3 months lone case dispose kavali, avtala party ki 21 days time is. So it is eating away a lot of time, maximum that is maybe. Okay, now, so what I mean is that the lot of time is being irrationally allotted at the different stages of the case. Mediation విషయానికి వచ్చేసరికి lawyers are permitted. Because that is one of the observations I have made in the act. So, friend, generally on the lighter side, I'm telling it. Our justice system is already dilatory, costly, and very costly. Morning, every suit you have to defend by a lawyer, and not all lawyers are easily available. Are the problem. So, I want to share an anecdote. What happens if the lawyers? Not all good lawyers are there. But in one case, what happened? A divorce case. Okay, now case was over. They are discussing what happened to your divorce case, and the lady, one of the lady was telling, yes, we have won the case. And then what about the children? The girl was given to me, and the boy was given to her. His father. And what about the property? And it is taken by the lawyer. The whole property is swallowed by the lawyer. Okay, so all these are practical problems when you come to mediation. 3 months. నేను ఒక arbitration case కూడా చూశాను. I have an occasion to deal with arbitration cases to support that, not fighting with it. Some 10 crore rupees property case. It is so prolonged already for years together it is running, the arbitration case. And mediation is also no exception. There are 3 months time is minimum given, but it is maybe further extended by the district commission. So what I feel is that the rationality of distribution of time under the act is not proportionate and not fair. That will eat away much of the time and making the process further delayed. So friends, these are some of the observations I have made. As I already said, I don't want to take much time and within these main observations of the act. So I take leave of you. Thank you very much for listening at this time in a summer after a lunch. And sir, thank you very much for giving me this wonderful opportunity of meeting all the people and through Sir Kesharao Garu, whom I admire a lot, and my madam also. At long time I could meet all, including my student Mr. Mallikarjun, one of my students at Varangal KU. So thank you very much for your patience hearing. Thank you.